sailors do what?
Good morning.
So, yeah, but it's fun being here in paradise, isn't it? So the first bill we have in the docket this morning before us is HB 1288, relative to the establishment of certain due process rights for students, student organizations, and faculty members facing disciplinary actions by state institutions of higher learning. And I'd like to welcome Representative Cortelli, who's going to introduce the bill.
Good morning, fellow committee members. For the record, State Representative Glenn Cortelli, representing Tufton Borough, Wolfboro, and Ossipee in the beautiful Lakes region. And it's my pleasure to introduce House Bill 1288, which I think is very timely and important. The prior administration in Washington proposed new Title IX rules related to due process when someone is accused of sexual harassment or something like that. Those rules are now currently the law of the land to provide greater options and due process rights to anyone accused from a complaint. And the current administration in Washington, D.C. has proposed new rules that roll those due process rights back. It is my understanding that there is a final draft of those rules available, but it is still just a final draft, and they have not moved forward to implement these new rules. But some of the issues that have been raised in relation to these new rules on due process for Title IX include, I'll just mention 3 or 4, a return to what is known as the single investigator model, which empowers a college administrator, a single administrator, to investigate, judge, and sanction any alleged misconduct. Secondly, the new regulations could deny students access to evidence against them, providing them only with a description of relative evidence, a summary of relative evidence, and that could be provided orally rather than any written testimony, transcripts, etc. Third, the rules also allow schools to deny accused students a live hearing and the opportunity to question their accusers, which I think is a major, major issue. Back in 2018, I'll just point out that when the previous administration's rules were being reviewed, there was an effort to postpone those rules put forward by Secretary DeVos. And the Foundation for Individual Rights and Expression noted that since 2011, and this was in 2018, so 7 years, approximately 117 federal courts and as well as a number of state courts had raised concerns about the lack of meaningful procedural protections in campus reviews of complaints. I think that the bill before us puts into place for New Hampshire some very important criteria for due process procedures. If you look on page 2, lines 4 and 5, the right to receive notice 7 days prior to a hearing. Lines 7 and 8, the right to receive at least 5 days before a listing of witnesses who have provided or will provide evidence against the student. Down to 11 and 12, the right to presumption that no violation occurred. Innocent until proven guilty, I think we've all heard about. Line 17, the right to confront and cross-examine witnesses. In other words, the right to a live hearing of the charges so that the accused can cross-examine witnesses. And on line 19, the right to provide defense and call witnesses in support of the person accused. I think all these are fundamental to our system of justice and certainly should be in any hearings on accusations on college campuses as well. And with these pending new rules from the current administration in Washington, I think it is very important that we set the standard here in New Hampshire. Thank you very much.
Thank you very much. Are there any questions of the representative? Yes, Representative Luno?
Sure. Thank you very much, Mr. Chair. Thank you very much, Representative Cordelli, for bringing this forward. Do the I want to go back to where you started with the federal changes to the federal due process rules, both made by the prior administration and being considered now by the Biden-Harris administration. But do the federal rules apply to all schools, public and private, that comply with the Higher Education Act?
I am not positive of that. I have read in one article that it might not apply across the board and could apply differently to private and public institutions, especially geographically, based on local federal court opinions. But I have not confirmed that.
Okay, thanks.
Further questions, Representative Bordiello?
Thank you, Mr. Chair, and thank you for taking my question. This is in regards to 17 on the first page of the bill, 17, and it's Roman numeral 2. Faculty member means a full or part-time member of the faculty. So would this cover adjunct instructors?
I would think so, but Representative Lynn will be testifying shortly and he is the prime sponsor and could answer that more accurately than I could. Thank you.
Thank you.
Further questions? Yes, Representative Woodcock.
Thank you, Chairman Leonard. Morning, Representative Cordelli. If I can follow up on Q's question, on line 17, just a clarification, if you may, where it says it does not include a faculty member who is on probationary status. Now, is that probationary status established by amount of time before being evaluated, or probationary status because they've done something in the past and now they're on probation for a disciplinary cause?
Again, I'll let Representative Lynn answer that question.
Okay, thank you.
Thank you.
Chair.
Further, yes, Representative Cornell.
Thank you. Thank you for taking my question. Could you reference where we can look to see where these pending rules are or what they are, or do you have a copy of that for us?
I don't have a copy of the draft rules, but I will endeavor to get that to everyone.
Thank you.
Further question, yes, Representative Luno?
Thank you again, Mr. Chair. When you talk about student organizations, why does it apply to why doesn't it apply to just student organizations that are recognized or approved, but also to, I guess, I don't know if you can call it a student organization, but a group of students who sought recognition or approval but failed to receive such?
I don't want to put words in Representative Lynn's mouth, but I would think student organization is one that has been recognized by the institution rather than one who has not been recognized. That's my opinion.
Follow up on that.
So thanks. Well, the reason I asked you is because I think well, no, Representative Lynn is the prime sponsor of the bill.
Correct.
So yes, if Representative Lynn is when he comes up, I'll ask about that, because on line 26 it talks about a group of students who may have been denied recognition.
Thank you. Any further, yes, Representative Woodcock?
Thank you. Thank you once again. I'll be done with this. Senator Cordelli, what prompted this?
I think, in my mind, it was prompted by information that we became aware of about the new rules that were being proposed, and concerns expressed about those rules. So I think it's very timely, in that the rules have not been put in place, but are still pending and in draft form. So I think we need to, if you might say, get out ahead of the game.
Thank you. Thank you, Mr. Chair.
There will be a number of other people coming forth to testify on this. So if it's a question that could be, maybe given to one of the others that are coming up, we have people from the university system as well as, further on this bill. Representative Damon, I'll recognize you.
Thank you, Chair Leb, and thank you for taking my question. It's actually a follow-up to Representative Woodcock's question. So I'm just trying to follow the history and maybe get a little more of it. This bill, as I understand it, proposes to secure in New Hampshire statute what is currently federal statute but may be changing. Is that, first of all, correct? And then I have a...
I think that the intention is to, yes, put into New Hampshire statute. I'm not sure if it exactly matches what is in current federal Title IX. Or I haven't looked at the current, but I did not draft this.
So this may in fact be for Representative Lynn, but just to put it on the table, how does this compare with what the federal statute was prior to, sorry, I'm having to make sure I say this correctly, prior to the Trump administration, because that's the current one. Is that correct?
That is correct.
Prior,
The current,
so then I mean prior to, before that. How does it compare?
some of the language in the proposed new Title IX regs are rollbacks to prior to 2018. I'm not sure if they all are. I haven't done it side by side, but some of them definitely are rollbacks.
Thank you.
So at this time, I'm going to call forward from the university system, Tom Cronin.
Good morning, Mr. Chairman, members of the committee. Tom Cronin, I'm the Executive Director of Government Relations for the university system. Good to be with you all this morning. So USNH is signed in opposition to House Bill 1288 as introduced. Our biggest concern with the bill is essentially it is laying out a one-size-fits-all framework for faculty, students, and student organizations across the university. At present, we believe we have ample due process to protect or to govern our community's disciplinary issues that allow flexibility and responsiveness depending on the issue at hand. Two really particular concerns we have. First, at present, our significant portion of our tenured faculty and then portions of our non-tenure lecturer and adjunct faculty are governed by 8 different existing collective bargaining agreements. Passing this legislation would require us to open every single one of those up in order to come into alignment with those agreements, which would obviously be a significant challenge. The second is for students and student organizations. House Bill 1288 would require comprehensive due process for all disciplinary issues. It required the same process for minor infractions that could lead to a warning as it would for more serious infractions that could lead to a student being suspended or expelled from the university. We certainly don't view major punishments like that as a minor thing that we would do without ensuring that our students have ample due process and opportunity to understand what the complaints against them are, the opportunity to question those, to work through a system before a final decision is made. So in our opinion, we believe the way that we currently operate in terms of our due process rights to protect, in some cases, property rights of our students, and in some cases, our faculty are well established and are working fine for the university system. As drafted, we're concerned that this would increase the number of hearings that we have to go through each year from around 80 across the system to more than 3,000. There is a fiscal note attached here that would be largely due to the additional man hours, the additional investigators, the additional volunteers. We'd need to go through all of those hearings that could range somewhere between $1 and $2 million in additional expenses a year. So those are some of our biggest concerns. We had, however, understanding obviously the views of the sponsors, if the committee is interested in moving forward, we had a few suggestions on amendments. One, you could exclude employees governed by collective bargaining agreements. That certainly handles one of the big concerns on represented faculty. Those folks do have clear disciplinary processes built into those contracts that are designed to protect them and their property rights. The second would be to remove the word reprimand from the definition of disciplinary proceedings. Reprimand is not defined anywhere in the bill, but the way we would view it is you're treating, again, to use an example that's prevalent on a college campus, a 20-year-old student caught with a beer can is being treated the same way as a student who could be potentially facing expulsion from the university. If we were able to find either a strong definition for reprimand to sort of suggest like it is an activity that is facing a severe punishment, or just simply remove reprimand and be clear that the bill only involves those most serious cases that could involve somebody being removed from the university. Third, Representative Luno sort of got to this. We would strike the language "or has sought recognition or approval from." As written now, you're sort of giving a right to a student organization that hasn't been established. So there's no difference in that case between a recognized student org and an unrecognized student org. And then similar, right now, the definition or the protection for student organization suggests that they'd be deprived either temporarily or permanently of any rights or privileges. We would ask you again to sort of be clear that this is a more significant, punishment that they'd be facing, potentially organizational suspension, dismissal, et cetera. That said, we think those amendments, if we were able to work through something like that, certainly reduce the likely administrative expense and burden across the system. Nevertheless, we would continue to argue that our existing processes work for our community, and a one-size-fits-all mandate does not. And I wanted to quickly, understanding certainly where Representative Cordelli was coming from in his testimony, my understanding from a quick conversation with legal counsel before he had to sneak down to a different hearing is that at least in the First Circuit where we are governed, we are required and believed a student facing significant disciplinary issues does have the right to cross-examine, which I know is one of the big questions as we look towards the new Title IX regulations. And then there is a bit of a circuit split just in terms of, as a public institution, what our requirements are in terms of due process compared to private institutions. So I'll stop there and try and take questions.
Thank you very much. Questions from the committee? Yes, Representative McDonald.
Thank you, Mr. Chair, and thank you for being here today. You mentioned that if this were to pass, you'd like some amendments. One of them would to be exclude collective bargained employees or union members. I understand there's two unions here today, so maybe they would better answer that, but how would you estimate what percentage or how many teachers are represented by unions, or would that exclude perhaps a large percentage of teachers if that was amended?
I'd want to get back to you on the exact number. A significant portion of our faculty, particularly full-time faculty, are represented.
Okay, and then you mentioned a follow-up.
Go ahead.
You mentioned that if this were to pass as is, you'd have to reopen up to 8 separate union contracts to rework those. Representative Cordelli mentioned that there is perhaps proposed changes to federal due process laws. Would you have to open up these union contracts anyway because of the federal changes?
My understanding is federal Title IX establishes a floor. Right now, what is in our collective bargaining agreements is above that floor. And I should actually, thank you for also reminding me of that. I think for the most part, our conduct folks on our campuses would suggest that right now, in most cases, with the exception of reprimands, when it comes to serious infractions, the due process that we offer, particularly our students, is well above what is outlined in the bill. so again, it's forcing us to pay attention to forcing us to have a similar standard for every potential incident across campus, as opposed to major infractions that would result in somebody being removed or temporarily removed from an institution.
Thank you.
I got a question, then I'll go to you, Representative Woodcock. Tom, within the K through 12 realm, where we have certified teachers, which is different than where you are, we also have a code of conduct. And there's 3 tiers there: reprimand, suspension, revocation of their teaching ticket. Within the 8 unions you're talking about, that there is a reference to this process. Is it a tiered system such as that we have within the code of conduct for a person that's certified? Or do you have any of those that may be available for us to look at?
Yeah, I would like to go back and actually get you exactly the documentation. I'm going to venture to guess that they are different, whether you're talking about the adjunct union perhaps at Keene State versus the full faculty union at Plymouth State. With 8 different agreements, there's 8 different ways to sort of think about these pieces.
Okay. And this, I'm sure, would be sort of similar to what's going on in the community colleges. I don't know, you don't represent them, but we're going to have Shannon
Yeah,
here.
Shannon had signed up. Yeah. So
Okay, thank you. Representative Woodcock.
Thank you, Chairman. You may have answered my question actually in your last comment. Mr. Cronin, just for my own clarification, when you're speaking today, you're speaking on behalf of UNH or of all the 4 years or of all the 4
the
years?
3 4-year institutions:
Just-
Keene State, UNH, Plymouth State.
Okay, just the 4-year chair.
Correct.
Okay,
And then-
thank you. Thank you, Mr. Chair.
You're welcome. Representative Lekes?
Thank you. Thank you for taking my question. I'm wondering why you would have to open up the negotiations with the unions when the union contracts are, you said above this in most cases, but you don't have to for the federal when it's above the federal. What is the difference between this and the federal?
Our read of this is it's very prescriptive, essentially. It is very clear on how we should follow, what the certain things we should do. And that is one of the biggest challenges. It is just very prescriptive.
Okay, thank you.
Further questions? Yes, Representative Balboni.
Thank you, Mr. Chair, and thank you for taking my question. I'm just curious, the prompting of this bill, what is your experience and your capacity? Have people objected to the process that you currently have in place? Do you have a lot of complaints about that?
To my knowledge, and then since receiving the fiscal note a few months ago and doing the research on this, I am unaware of somebody saying that the process, our due process, is not working at the university. Yeah, and again, I fully understand the sponsor's intention of trying to get ahead of something that may be coming from the federal side, but I didn't hear in the testimony that it was in reaction to something currently happening at one of our institutions.
Representative Ford.
Thank you, Mr. Chair, and thank you for taking my question. Is there a distinction in your process between a written and a verbal reprimand? Is one a matter of record and the other not?
It's a good question, and again, that's part of the concern we have here is a faculty member perhaps telling a student you need to start showing up on time or there will be consequences. Is that a reprimand? We're unclear. Versus sure, if a student is in violation of, again, let's use caught with a can of beer underage, like they would probably have something written and put into a file at that point. And there are steps you could go to essentially be on, university probation for some limited period of time, depending again on the severity of the violation. And that's what our biggest issue here is. It's unclear that there's any scale for severity.
Thank you. Thank you very much, Tom. Oh, Representative Damon.
Thank you. How does the university due process system integrate, or I'm thinking not, with the court system?
So we certainly review our, student rules, rights, responsibilities is one of the key driving documents here regularly. In the event that there are court cases that would change how we've written or implemented certain processes, we go back and adjust as a result. Again, I think our policies are strong and we haven't been involved in those lawsuits, but certainly as things are happening around the country, particularly in the First Circuit, as I mentioned, we're reviewing those cases, and if we need to make amendments, that's what we do. I hope that partially answers the question.
Not seeing any other hands here.
Perfect.
Thank you very much.
I have written testimony which does outline those 4 items that I'll
Great.
address.
I'd like to call forward Shannon Reed.
From Diana just that she's in the Senate, if any questions come, she's not sure if he's going to be here this morning or not.
Okay. Okay. Good morning.
I should know by now. Shannon Reed, representing the Community College System of New Hampshire. Nice to see you all. We've signed in opposition to this bill. I'm here as much in listening mode as testifying mode because I was interested to know why it was felt that this bill was necessary. We have comprehensive policies, of course, that govern both student and employee disciplinary matters. And then, of course, for employees, we also have protections that are negotiated and enshrined in collective bargaining agreements. I'm not aware of any review of our policies or our practices or our outcomes that have suggested any inadequacy in our current policies and processes. Again, I was interested to hear Representative Cordelli's introduction to this bill referring to some pending Title IX changes. But again, those are pending and only affect a particular piece of a very broad disciplinary picture. So I am not an expert on Title IX policy or indeed our disciplinary procedures. We have pages and pages of policy and procedure. And a lot of what I heard in the introduction are also part of our policy. For example, the presumption of innocence, the requirement for timely notification, for hearings and appeals, the ability to call witnesses. So we have a lot of those protections currently in policy. This bill would replace our existing policy and processes and negotiated protections with a set of different requirements in a new chapter of New Hampshire law. Again, that would require for us essentially a wholesale replacement of what we currently do with new practices that would have to be learned and taught and staffed and institutionalized across our institutions, where I can't say that I'm aware of any problem that would necessitate that significant and broad change. But likely the largest impact of 1288 would be a significant increase in the use and cost of legal representation. And I'll refer back to what Tom Cronin just said about how this bill seems to encompass everything from the most minor offense to the most serious and consequential offense. So, for example, a student noise complaint in a residence hall, a faculty disciplinary matter that might involve attendance, inadequate attendance, that would trigger, as I read it, the same protections that would also be in place for the far more serious offenses that could result in separation or some kind of more serious sanction. So the cost to CCS&H could easily reach $1 million a year. I think in my fiscal note, I'm informed by my colleagues, I was very conservative in estimating what that might be, but given the range of sanctions that would put into play legal representation, it would likely be much higher. And the anticipated scope and the number of proceedings that would be subject to these new requirements would very likely create also significant delays before decisions could be reached. You know, you can imagine the range of activities on a college campus, and if all of these are now going to be subject to a kind of an enhanced process, then there will likely be changes in the timetables of resolving these issues. Again, we have comprehensive policies and the collective bargaining provisions. Enactment of this bill would remove these matters and these processes from the purview of institutional policymaking, from the internal evolution of the student code of conduct, and from the employee bargaining process. These processes and instruments are designed to be responsive to the college context, institutional, student, and employee needs. And I provided a couple of examples where the inclusion of reprimand, letter of reprimand, that kind of lower level sanction would trigger the provisions of 1288. I think that most direct change would be that the institution would need far more involvement of legal counsel in procedures that now are handled not typically with attorneys at that lower end of the kind of sanction scale. The bill also appears to prevent, and this is sort of a specific and a specific point that might not happen often, but the bill also appears to prevent the institution from imposing any type of discipline until the proceedings are completed, unless we can show a substantial likelihood of an imminent threat of physical injury or damage to property. There's no allowance for an interim sanction that might be put in place to provide for to allow the institution to act out of prudence to protect any party other than in the face of the threat of physical injury or property damage. And I can think of a situation where there's been an accusation that might warrant removal of an individual from the campus for a period of time until an investigation reveals more of what actually happened. There doesn't appear to be the ability to do that interim kind of sanction while something is being kind of investigated and figured out. I'll just summarize by saying we believe our existing policy and our ability to negotiate protections through collective bargaining are the appropriate ways to arrive at a complaint and disciplinary processes that are fair and sound. We are kind of all waiting to see what happens with Title IX. And I would hope to do a fuller analysis of kind of the conflicting or duplicative impacts of what happens on the federal side before something is enacted in state law. So I'm happy to try to take any questions.
Are there any questions for the community college system? Representative Luno?
Thank you very much, Mr. Chair. Thank you very much, Ms. Reed. I want to sort of poke at the example you mentioned earlier about maybe a noise complaint, and I think maybe anybody that's gone to college or has had children in college have been aware of maybe a noise complaint or two, and in the I guess with the policy, with the proposed policy that's before us right now, if there were something like a noise complaint, maybe a room 2 doors down from my daughter's room is they're up late making a lot of noise, and my daughter's trying to study, how would that be? How would the RA handle that now? And how would it most likely be handled under, if you had to comply with this sort of one size fits all?
I'm actually not 100% sure how that would be handled under this bill. Something like that, there would be certainly attempts to come up with an informal resolution, right? A more serious, but in the same kind of universe type of thing would be if a student propped open a door of a residence hall to allow someone in later, or because they keep losing their access card or something like that. That's a little bit more serious. Yeah. Not so much a kind of student down the hall type of an issue, but more of a safety issue. There is an attempt made to come up with an informal, resolution to sort of mediate that. I think that under this bill, that kind of thing would be, the student could have an attorney representing him or her, cross-examining witnesses, something that seems inappropriate to the level of offense. So our policies right now are kind of stepped along the spectrum of collegiate activity and potential sanction, and we feel that is the appropriate way to address the range of things that can happen on a college campus.
Okay, thank you.
Yes, Representative Dry.
Thank you, Mr. Chairman. Thank you for coming to testify. Given that Title IX changes are probably coming, is this bill fixable? I mean, if you took into account reprimand like UNH was asking and bargaining and perhaps interim measures, is it something worth working on to set the ground for that?
I'm sure on the one hand that tweaks or adjustments could be made to the bill so that it would constitute an appropriate set of policies. I think my one of the points I made earlier is requiring the institution to essentially replace an existing and known set of rules and procedures with something new is in itself a major undertaking. And I would say there needs to be good reason to do that, a problem, an inadequacy. And I'm not aware that there is, in this case, a significant gap or problem or abuse or inadequacy in how we're presently set up to handle disciplinary matters.
Okay, thank you.
Shannon, I have a question I'll get to you. Years ago, we had an issue with one of the private institutions in the state where there was sexual misconduct going on, and it came down to the investigation. Do you do the investigation, or do you work with, as a result of that previous case we dealt with, an MOU was put in place between the local police in that particular community and the university or college? Do you have something like that in place right now to investigate the situations may come up? And where is this start and stop between you doing it and then the local authorities doing it?
I would say that anything that is a potential criminal offense is reported to local law enforcement, and it's dealt with separately in the ways that are set up through the criminal justice system. Likely, such an incident would also be a violation of a student code of conduct or employment rules, and it would be dealt with concurrently in that way, but informed by what happens in the extra institutional or the legal realm. Does that make sense? Does that answer your question?
Well, I don't think we're going to be able to get to the answer in this one without a lot more discussion. In the case I'm talking about, we had the college taking care of some of these issues, which were clearly on the other side of the coin in the criminal area. And the town didn't know anything about it.
I'm not familiar with the example you're...
I'm talking about Dartmouth.
Okay.
And it had to be resolved by the attorney in Grafton County. So I just asked that question, see if there's something like this in place where you know where the line is that you, so there's a due process afforded to the student. And if the student decides that, if there's a disciplinary action taken by the college or the institution, yours, is there a process for the student to say, nah, I want to take this, in a different direction?
Yeah, I'm not sure I'm going to be able to answer that right now.
Yeah, I got you. Any further questions, Representative Woodcock?
Thank you, Chairman Lett. Good morning, welcome. Just to clarify my own misinformation probably, I'm thinking of community college students for the most part being generally a little older, a little more mature. So, and I may be wrong, I'm thinking different demographic of youngsters or young adults that go there. What is the ballpark breakdown guesstimation on high school age type students that go versus older that attend? 'Cause I'm trying to think of, and that's just one in the second part of that same question. How many do you have ballpark that you actually have residential settings, if you may?
Sure.
Thank you.
I
Thank you,
think
Chair.
the demographic of our students is in fact indeed broad, as you suggest. We have about 60% of our students who are under age 25 and 40% that are over age 25, roughly. In residence, we only have 2 colleges right now that have residential students, NHTI in Concord, which has about 300 students who live in campus dorms, and Lakes Region Community College in Laconia, which has kind of adjacent housing that houses about 70 students.
And thank you. Just to follow up to that residential number, how many then are non-residential? You're looking at maybe 400, 500 there in your whole system, community college system enrollees. How many actual enrollees? That'd be my answer.
Right. I mean, all in, we serve about 21,000 students a year. A significant proportion of those, though, about 8,000, are still in high school.
Okay.
And they're taking dual
Right.
credit courses
Okay.
through us. So,
So
you know,
this is-
roughly an FTE a credit FTE of about 12,000
Yeah.
students, and,
Okay,
you know,
maybe one.
under 500 are new
Very-
residents.
Very small number. Hey, thank you very much. Thank you, Mr. Chair.
You're welcome. Representative Lakis?
Would the community college need to revamp things if the federal law does go into effect?
I'm sure there would be some adjustments on the Title IX side.
Okay, thank you.
Thank you. If there's no more questions, we'll call forward Representative Lynn.
I'm sorry. Thank you, Mr. Chair, members of the committee. I guess what I'd like to do, I think Representative Cordelli sort of in his introduction sort of explained generally the bill, but you've had a number of questions, and what I'd like to try to do is respond to the questions, and I hope I'm doing this in roughly the order that they were raised. There was initially a question about whether the definition of faculty member, where it says means a full-time or part-time member. And I think the question was, would that cover an adjunct? I mean, obviously, it would be up to the committee if you thought it shouldn't. My inclination was that it should, that it would cover, you know, a part that by part-time I meant to include adjuncts. There was another question about probationary status, and that's a very good question. I mean, maybe that means that the language would need to be changed. My intention was not to cover somebody that's on probationary status because they've been subject to some kind of discipline, but rather I meant somebody that I assume that there's a process when if you first get hired, that for some period of time you're on probation. That's the kind of probation I meant. But you raise a very good question. Maybe that needs to be changed to say, you know, is on a new hire or some language like that. That's what I intended. Then the other issue, and I very much appreciate the representatives from the university system and the community college system being here, because I think they raise some good points. For example, the question about reprimand, should that be covered? They raise some good points on that. I think your point, Representative Luno, about, you know, somebody's yelling in the dorm or making a loud noise. Do you want to invoke all of the full due process areas there? I would tend to agree. If it's just something as simple as that, you know, maybe that's not required. So maybe, I guess what I would suggest is it may not be as simple as simply removing reprimand from the language, because my sense is that there may be reprimands and then there are reprimands. If you were intoxicated some night on a Friday night and you were making too much noise in the dorms, and they said to you, cut it out, don't do that again, or you're imposed some very minor kind of consequence for that. Maybe that shouldn't be something that is covered by sort of the full due process. On the other hand, what I would be concerned about is if you completely remove reprimand altogether, could there be serious reprimands that if they could be imposed without affording due process, that could be used as a method to really very badly damage someone's reputation. In other words, if for example, suppose suppose that there were an allegation of some kind of sexual assault, which if true would be a really serious matter that somebody who had committed that should be, maybe should be expelled or whatever. But the evidence was not sufficient to sort of support actually doing that. And so in an effort to avoid having to make a hard decision, the institution decided, well, we'll just issue a letter of reprimand here. We don't have to go through all the due process standards. That I think would be a concern. So I guess what I'm suggesting is maybe there is some middle ground here where you might say, a reprimand, a written reprimand, for example, that would be permanently a part of someone's student file or something like that. I'm just, thinking off the top of my head here, but I would think that it might not be appropriate simply to remove all reference to a reprimand. If you could in some way sort of change the language, and I would obviously be happy to work with any members of the committee on this, just to make it clear that what you were talking about is sort of a serious reprimand, something that was pretty serious, and that could have lasting sort of reputational consequences on the person. Then it would seem to me the person ought to be entitled to due process. Now, with regard to the issue that was raised about collective bargaining membership and the need to change all of the collective bargaining agreements, that kind of thing. I think several of you raised very good questions to the witness who testified in that regard. And I think if you listened carefully to what he said, in the end, it seemed like he really sort of came around to saying, well, really, maybe this isn't such a big deal after all, because it sounded like most of the collective bargaining agreements that we're talking about, and I have to say, I haven't reviewed those collective bargaining agreements. I don't know what they say, but it sounded like, if I was listening correctly to what he said, is that most of those collective bargaining agreements encompass the due process rights that we're talking about here. Maybe not every single one of them, but it sounded like most of them do substantially incorporate those kind of due process rights. And I would note in that regard, please don't forget to look at proposed RSA 188J4 on page 3 of the bill that indicates, and I'm quoting now, any New Hampshire public institution of higher education may adopt rules, regulations, policies, or procedures that afford students, student organizations, or faculty members more due process protections that are provided in this, but none shall afford less due process. So if, as it seemed to me, the witnesses were saying, the collective bargaining agreements do contain due process that are basically equivalent. Now, I'm not saying that they might not have to change one or two little things, but as they seem to acknowledge, it would seem that they may have to do that in light of Title IX changes anyway. So might they have to make some adjustments? Perhaps, but it seems like most of the, I would expect that the people representing the union side of the negotiations obviously are very concerned to make sure that the people they represent have due process protections. So I would suspect that many of those are close, maybe not exactly the same, but pretty close to what is provided for here. So I really don't think that that's likely to be a huge issue. And remember that there are many people that are not covered by the collective bargaining agreements that could easily be subjected to some form of disciplinary action. The last point I wanted to respond to, and then I'm obviously happy to answer any questions you may have, is the question about should this bill apply to organizations that sought approval? And And I guess I think that there is a legitimate concern there. If some group sought approval for their group and for one reason or another they were denied, I'm not suggesting that this would happen, but it could, just take an obvious example. Suppose that the faculty at UNH says, oh, it's fine to have the Young Republicans Club on the UNH campus, but we can't have the Young Democratic Club. Shouldn't they? And we're not going to recognize it. Shouldn't they be able to say, wait a minute, what are you talking about? Of course we have a right to do this. You're allowed. Or suppose, maybe a less subtle example. Suppose the UNH group every person for gun safety or something, they get recognized, but there's a pro Second Amendment group that wants to be recognized and they're not. Shouldn't they have the right to be to say, wait a minute, you can't do this. We have a right to recognition also. So I do think that there's a reason why groups that are seeking recognition should have the protections of this bill. And I guess the very last point I'll make in response to the testimony of the person from the community college system about, are there circumstances in which we need to remove someone? We want to be able to take some action like removing someone from campus before there's a hearing. I certainly can see situations where that might be appropriate, but it would seem to me that it would be that in the circumstances in which it would be appropriate, there needs to be some basis of saying there's some kind of, it's dangerous to keep this person on campus. And I think that the exception for that is contained in the bill. If there really is a basis for believing that there's some physical danger to other students or faculty or whatever, or some danger to property, of course, the institution should be able to remove the student before they have a hearing. But if that's not the case,
Your mic just went off.
well, I'm sorry, but if that's not the case, then I don't think that they should be able to. I think the student should be afforded the hearing first. So with that, I'm happy to answer any questions.
Thank you very much, Representative. Representative Belcher?
Thank you, Mr. Chair, and thank you for being here for this testimony. Thank you for presenting this bill. On the whole, I certainly agree with the concept. Maybe a few portions could use cleaning up. I have a couple concerns I hope you could speak to. However, page 2, lines 15 and 16, the right against self-incrimination, except that invocation of this right may afford a basis for the decision maker to draw an adverse inference against the person who does. Do you think there might be cause there for concern that there could become a coercive environment for proceedings or investigation if there is allowed to be a negative inference drawn from somebody invoking their right to remain silent?
Well, you know what I would say? I put that in because, remember, these proceedings are not criminal proceedings. It's these are, for lack of a better term, these would fall under the broad general category of civil kind of sanctions that would be imposed. And there is a sort of recognized body of case law that says in the civil law context, a person still has the right to invoke the privilege of self-incrimination because potentially there could be a criminal charge could be brought. But in the civil context, it is generally permissible for the fact finder to draw an adverse inference. And so that's why I put that in. Is there some potential for coercion? I suppose you could make that argument. I would tend to think that it might, that on the whole, it's not, this is not a bad idea. I guess that's the way I'd answer.
Thank you. And if I may, real quick, because that was the perfect segue into the other question I had. And I'm not sure it's specifically addressed in here. I'm hoping you can speak to whether or not it would touch on it. I have seen elsewhere, and our chairman brought up an example of this, the idea of a criminal allegation being adjudicated at a college. Obviously, colleges exist in this gray area where they have to have disciplinary proceedings, but they have not been established as courts by this legislative body. So my inference there is that they may have to take disciplinary action, but they have no right to adjudicate guilt in a criminal matter. So would that be something that this bill has anything to do with, or if not, do you think that might be an appropriate addition to this bill to preclude the adjudication of guilt, just guilt, in criminal allegations?
Well, I mean, the only place that criminal guilt can be adjudicated is in a court. And so I don't think that, there certainly could be overlapping. I mean, behavior could constitute both a crime that could be prosecuted by the county attorney or the attorney general in court, and also be the basis for disciplinary action by the university system or community college system. And I don't think this is intended to cover criminal conduct. And I don't think the university system would have the authority to adjudicate guilt in the sense of, like, you're guilty and we're imposing some criminal punishment.
Thank you.
Yes, Representative Cordiello?
Thank you, Mr. Chair. Thanks for taking my question. It is, again, in regards to that same part I had, my last question about adjuncts, line 17 on page 1. But this part, exception does not include a faculty member who is in probationary status. Could you speak to why you have included that? And you've already clarified that this is in regards to a new employee rather than someone who is on probation for, like, doing something bad. Are they not also entitled to due process? So if you could speak to why you have put this exception in there, and if perhaps it is not necessary.
Sure. Certainly in terms of, could you take it out? And so that everybody, including sort of brand new employees, would be subject to the due process protection. Yes, you could. I put it in there because I guess, I do agree with the prior witnesses who testified. I'm not, I understand that there is an institutional interest in limiting the number of hearings that this can be imposing these requirements and requiring hearings can be a burden. I just sort of assumed, and I think my inclination, I could be wrong on this, and maybe somebody would correct me if I am. But for example, even in most collective bargaining agreements, I think that there is often an exception that all the rights that a union member has don't kick in until they've served a certain period of time. And so it was along those same lines that I thought that it made sense to exclude people that were new employees basically on probation. But again, do you have to do that? No, you could cover them too, but I think you then impose a sort of greater burden of perhaps more hearings on the institution. And that's why I did not put that in.
Further questions, Representative Luno?
Thank you, Mr. Chair, and thank you, Judge, for joining us this morning. In your opinion, what are the problems with the current university and community college policies?
Well, I guess, I would say this. I think my understanding, and I want you to understand, this isn't something that I've, deeply researched, but from what I understand, based upon what I've read in, various newspapers, various publications, the university system, I think the state college system is generally not bad in terms of compared, for example, to private institutions such as Dartmouth, where, free speech free speech on Dartmouth is at a premium. It is less so, I think, in the university in the university system, the state colleges. But I as Representative Cordelli explained, there is a very great concern, I think, that starting with the Obama administration and what bear in mind what the way much of the proposals that were submitted and implemented during the Obama administration in this area. It's not even clear that they actually were sort of valid regulations. The Secretary of Education would send out, dear John kind of letters proposing sort of guidance that weren't really proposed as regulations. They were guidance. So your guidance is you don't really you don't really have to have much in the way of due process when somebody's accused of having sexually assaulted someone else. That's not very. It's much more important to provide comfort to the person who has allegedly been wronged than it is to afford due process to somebody who's been accused. And so you had this guidance suggesting you should do this, and candidly, because most of the institutions shared the philosophical outlook of what was being proposed by the Biden administration. Most of them did. They adopted. Oh yes, we're going to do this. And then when the Secretary DeVos came in and changed that, some institutions did adopt what Secretary DeVos said, imposing more stringent due process protections. And now there is this concern that we're going to turn the clock back with some proposals that have been made by the Biden administration. And so I think that having a state law that says you can't do this. This is what needs to be done, because bear in mind, there is real questions. And I think to the extent that these issues have been adjudicated, I think in particular, there was a case from the Seventh Circuit, if I recall, when Justice Barrett was still a circuit judge, that really raised questions about whether the federal government had, under the Education Act, actually had the authority to issue these quote unquote guidance letters. But my purpose basically was to ensure that due process is protected in New Hampshire, regardless of what guidance or other proposals might be issued by the current administration.
Just quick follow. We do have one more person to testify.
Okay, but Judge Lynn would be the person to ask this. So given what you just talked about, and in particular, very prescriptive due process provisions versus maybe less prescriptive due process provisions, I was wondering how you think. Maybe the comments from the former president of Harvard may have been impacted by a more prescriptive due process policy, such as this.
How they may have been. Frankly, I'm not quite sure.
I'm really getting at is there a point with which with which a prescriptive due process policy would prevent a college president from being able to make a specific call on behavior on campus?
To make a specific call.
Yeah.
Well, no, I don't. I mean, I don't think so. In other words, if a to you, to get at what I think you're sort of suggesting is this: if a college president were to take disciplinary action against some students, for example, for engaging in anti-Semitic behavior, please understand, on the merits of that, if they in fact did that, should and should there be disciplinary action? I would, obviously, depending on the facts, I would tend to say absolutely, but it's like it's like anything else, that it depends on the facts, and I don't think that that if the students say, "Wait a minute, I didn't do what you've alleged that I did," or you've really overstated what happened here, I think that the students, whoever they are, whether they're, whoever they are, should have the right to have a fair hearing. And so, if that due process always, in fact, it's meant to, it always restrains someone who would like to act right now and impose their will. It always restricts them from doing that. And that's exactly what due process is all about. It's to make sure that we don't act precipitously, that we find out what really happened, and listen to and give the person who's accused the opportunity to have their day in court, for lack of a better term, or for a hearing, before you take some precipitous action. And I think that's pretty important to do that.
Further questions? Thank you very much, Representative.
Thank you.
And lastly, Greg Gonzalez from Fire. Welcome.
Thank you. Happy to be up here. Chairman Ladd, Vice Chairman Cordelli, and members of the committee, my name is Greg Gonzalez, and I'm Legislative Counsel for the Foundation for Individual Rights and Expression, also known as FIRE. FIRE is a nonpartisan, nonprofit organization dedicated to protecting the free speech and due process rights of students and faculty at our nation's institutions of higher education. Throughout its nearly 25-year history, FIRE has defended students and faculty on all parts of the political spectrum. We have also advocated for campus due process legislation in state houses across the country. We are pleased to see that a campus due process bill was introduced in New Hampshire. This bill will enshrine important protections for college students into state law, such as the express presumption of innocence and the right to active assistance of counsel. I hope we can all agree that before a student is removed from the college of their choice and possibly have their entire educational careers ruined for allegations of wrongdoing, universities must follow fair policies and procedures to ensure that they get the ultimate decision right. As many court cases across the country have shown, it is unfortunately common for universities to sidestep many of these protections when they are not expressly guaranteed in law. However, this bill would benefit from crucial amendments. Most importantly, the provision that the right to remain silent being invoked by the accused can be construed against the accused must be removed. Since most of the incidents these college disciplinary proceedings may overlap with potential criminal law proceedings, the choice to remain silent in campus proceedings may be advisable and should not cut against students who may be taking advice from a defense attorney. This provision is also in conflict with existing federal Title IX rules, which prohibit institutions from drawing inferences against either a complainant or respondent based on their silence during cross-examination. Further, we believe other provisions would benefit from additional clarity or substantive additions. FIRE has model legislation, portions of which have been enacted in 9 states. In fact, over the past 2 years, in Arkansas, Louisiana, and Kentucky, such legislation has been passed unanimously. It has been signed into law by both Democratic and Republican governors. I would urge the committee to take a look at those pieces of legislation and our model to shore up this bill and to ensure students in New Hampshire have the best possible protections. Thank you. Before I finish, we also had the very similar concerns as many others with regard to the word reprimand in this bill. Looking into making changes to that certainly advisable and something that we would be interested in working with the committee on as well. For instance, our mall legislation focuses on infractions that would result in suspensions of 10 days or more, or an expulsion. And we do that because that's in keeping with Supreme Court precedent in Lopez v. Goss, which said that in situations where a student's education could result in like I said, a suspension in 10 days or more, or an expulsion, that's when due process is necessary. So that's why we have that in our mall piece of legislation. But of course, you can do much, go further than that, of course. But we understand that reprimand is certainly an issue that can be looked at in this bill. So
Thank you
I look
very
forward to
much.
any questions.
Representative Luno.
Thank you very much, Mr. Chair, and thank you very much, Mr. Gonzalez, for being with us here this morning. I was wondering if you could, let us know currently how, or I guess where our state universities stand in terms of their rating with your organization.
So in the due process realm, I would have to really take a look at the policies, but off the top of my head, I can't remember any particular issues with the current due process language. But I will say that for this type of issue, you don't want to wait till there's a problem, right? There are plenty of court cases across the land where there are universities who thought, they came and said that they were doing the right things all along, when in reality they were not. You have cases where there's no live hearing, for instance, which actually this bill does not actually have. So that's another change that we would welcome into this bill, was an actual live hearing. So you would just have investigators take some statements, and then they would end up being the kind of judge, jury, and executioner. Representative Cordelli mentioned the return to the single investigator model, which is possible with these new Title IX, pending Title IX regulations. So that could happen if legislation isn't enacted. It won't be necessarily mandated in the new Title IX regulations. They usually say, they may kind of do this, but during the Obama administration, that's exactly what universities were doing. They're allowing the single investigator model to go forward. So, while there may not be any issues right now, you don't want to wait for students to be essentially railroaded out of college for that to happen, for changes to be made.
Yes.
Thank you, Mr. Chair. How about with the university's ratings on Fire's speech on campus?
I'm going to hear for the next bill as well.
We know it's high, like fourth in the country, but that's the next bill.
No, I understand that, but clearly there'd be a relationship between your policies on speech and campus and your policies with respect to what the subject of this bill is. So it would be inconceivable to have policies that were 180 degrees out of sync with each other on that. So just to be able to, since you don't have the information on, and we haven't been able to find get any testimony on information about any current problems with UNH's due process policies. Let's swing over to what will often behavior that could result in due process, and talk about that behavior and where our universities stand with respect to Fire's rating on that.
Yeah, so we are happy to say that UNH is currently ranked number 3 in Fire's campus free speech rankings. Number three out of 246.
Okay, thank you.
Universities rated. Now, that does not mean that they have a perfect score. Their score is about, I believe, 72. So I believe that's a C in most grading scales. So I believe that anyone that's getting a C certainly has room to improve.
They do a good job at UNH.
Yeah.
Let's just put that in the minutes. Further questions? Thank you very much. And with that, this closes the testimony for the bill we're on, 1288, and we will shortly get into the next bill, which is freedom of speech. And let's see what we got here. Ooh. Yeah, anybody on the committee that has to take a break, do so. And don't be bashful doing it when we're having the hearing. You need to take a walk. We'll start this up in a few minutes. See,
I think I have to leave, I stayed a little longer than I was, going to, but the Eclipse bill was interesting.
yeah,
I'm gonna have to leave after this one, 1436.
yeah, okay.
And then tomorrow,
We ought to have it.
I can only stay until 11:30. So I'll just let Margaret know.
Yeah.
Excuse me, next bill, someone testifying in support, he said, you want to testify somewhere else. He's from the Legislative Youth Advisory Council.
Okay,
James.
yeah.
So he just said put him towards the end.
Sure.
James. There he is.
Let's go to the end.
Okay, good.
Thank you.
That works. How are you? Good.
Is that just close in point of order? And say that?
Good.
Well, we have a question.
Yes.
You're a sponsor and very kind of that as well. Am I able to ask questions?
Remember.
Thank you, Mr. Chair, members of the committee. I'm Representative Bob Lind from Wyndham, and I'm one of the co-sponsors of this bill. And I guess, again, I think the bill, I'm happy to answer questions if I can. I think the bill is relatively straightforward. It is designed to guarantee that free speech rights are protected in institutions of public higher education, and that it's designed to, for example, to prohibit the establishment of sort of free speech zones, some narrow location where free speech is allowed, but everywhere else it's not allowed. Just as an example, it's designed to prevent other sort of intrusions, if you will, on free speech on campuses, while also allowing the institutions to maintain reasonable time, place, and manner restrictions. That I think that does have to exist, and it is provided for in the bill. So with that, I'm happy to take any questions.
Are there any questions of the representative? Not seeing. Thank you very much.
Thank you.
I'd like to have Representative Popovich Mueller.
Would it be possible to ask to close the discussion? I would like an opportunity to speak at the end rather than now, if possible.
I can put you at it's been introduced, so if you'd rather speak at the end, that you're.
I would much appreciate that, yes.
Thank you.
Thank you, Mr. Chair.
Okay, we'd like to have next then Lance, is it Kinzer?
Yes, sir.
Yes, thank you.
Well, thank you so much. My name is Lance Kinzer. I'm here on behalf of First Amendment Partnership. I have some written testimony that I'd like to perhaps. Note, I was here last year in February on a very similar bill, and I know the committee is well advised on most of this bill, has had an opportunity to hear testimony before, has had an opportunity to discuss the bill. So I'm going to try to focus really briefly on just a couple of things that I hope will refresh your recollection on the purpose and kind of the intent of the bill, but also provide a little bit of an update. And my area of expertise, to the extent that I have any, is really on the student association portion of the bill, that portion of the bill that protects the ability of student associations to choose leaders who agree with the mission and purpose and agree to live consistently with the mission and purpose of the organization. This issue has resulted in a significant amount of litigation over the past several years, perhaps most dramatically in Iowa, where ultimately in 2022, the U.S. Circuit Court of Appeals for the Eighth Circuit found that targeting of religious groups, not allowing them to choose their own leaders based upon the religious views of those organizations, was such an egregious violation of well-established constitutional rights that the university administrators who had made that decision did not have qualified immunity and were actually personally liable in that case. For one of the groups that was involved in that litigation and that's been involved in much of the litigation in this area is an evangelical campus ministry called InterVarsity. And I think you'll see they weren't able to be here today in person, but I believe they've provided already some testimony online. And the point that I want to make about this is that in instances where these issues are litigated, it's increasingly the case that student associations who are forced to litigate over these issues are winning. They're winning in dramatic fashion, and they're even winning some pretty big judgments. In the University of Iowa case, the taxpayers of Iowa were ultimately on the hook for a $2 million judgment, approximately, that they ended up paying out. But InterVarsity although they can win these lawsuits, doesn't want to be involved in lawsuits. It's a distraction from their mission. And what they're advocating for, and what we're here speaking in favor of today, is really an attempt to limit litigation by establishing clear standards that are consistent with the way courts have more and more been interpreting what the Constitution has to say about the right of student associations to choose their leaders, consistent with the views of those groups. And that leads me to the kind of update from last year. Most recently, there was a case in the U.S. Circuit Court of Appeals for the Ninth Circuit involving Fellowship of Christian Athletes versus the San Jose Unified School District. Now, that's obviously, by the case title, a K-12 case, not a higher ed case. But in that case, the Ninth Circuit, sitting en banc as an entire court, went out of their way to say, we're going to go back and clarify our circuit's precedent on higher ed issues related to student associations, because the direction the U.S. Supreme Court's been going on this issue is so clear. And so the Ninth Circuit ruled, and I think this is really the key, because oftentimes the distinction has been that, let's say we have we have religion as a protected class, and a religious group wants to have religious standards for their organization, a religious campus ministry. And sometimes there's been confusion. Well, is it religious discrimination for a religious group to have religious standards for its leaders? And unfortunately, that's kind of at the core of a lot of the litigation. And the Ninth Circuit, consistent with some rulings of the U.S. Supreme Court, has said very clearly recently, in the higher ed context, anti-discrimination laws and the protections of the Constitution work in tandem to protect minority views in the face of dominant public opinion. Just as it makes sense in that case for the Senior Women's Club to have all female members, just as it makes sense for certain clubs to require good moral conduct of their members, it makes equal sense that a religious group be allowed to require that its leaders agree with the group's most fundamental beliefs. The Ninth Circuit revised their circuit precedent to make this more clear. My point that I want to make, and I'll leave you with this, is that the student association portion of this bill, which locks in the ability of student associations to have standards for leaders, it's particularly important for belief-based organizations. It's been especially problematic for a number of religious organizations. The design, the intent, the heart of that provision that 17 states have passed, including Indiana unanimously, including Louisiana, where a Democratic governor signed it into law, is to avoid litigation, to create a clear standard so that students don't have to retain legal counsel, sue their own universities. You'll recall from last year that there was a group from First Liberty, the Christian Legal Society, that came in and testified about issues they'd had at the law school. I believe you'll be receiving written testimony from both of those groups, providing a bit of an update. But I'd be happy to answer questions. I just want to say, I believe that what we have in this bill is a codification of the direction courts are rapidly moving on what the legal standards are, and that by having this in statute clear, the result will be less likelihood of litigation, more clarity for administrators, more clarity for student groups, and it's really promotive of pluralism. And so that's why we're here to speak in favor of it today.
Thank you very much. I do have a question for you.
Yes, sir.
Where does the First Amendment start and stop here in regard to true threats, expression directed to provoke imminent lawless actions and likely to produce it? Prohibiting harassment as expressed directly to, prohibiting harassment as defined in RSA 188, etc. I'm concerned, where does the line, is there a line there where you're the way you're expressing yourself, the freedom of speech, leads to lawless activity, and how is that addressed?
Yeah.
Through the First Amendment.
So I'll begin by saying that there are a couple of people who are going to testify after me, particularly the person from FIRE, who I think is focused more on that portion of the bill and may be able to give you a better answer. But my answer would be that this area of speech, say in relation to incitement, is an issue that's been well litigated over the years. The courts have established standards regarding through a host of cases. And we really do, as we do in many instances, look to the case law to see where those lines are drawn. And my understanding of the speech zones portion of this bill, not the portion that I know as much about, but my understanding of this bill is that it's largely intended to recapitulate language that courts have used, that courts are familiar with, so that when this standard is the standard that's in front of them and these issues are being adjudicated, they're using very common standards and using standards that courts are familiar with. And so there are some line drawing questions that arise throughout this bill. That's not that's not uncommon with respect to much legislation that gets passed. But I think the real benefit of this legislation is that it uses language, it uses standards that are very consistent with the way courts have dealt with these issues in the past, continue to deal with them. And the real purpose overall of having this just clearly in a state statute is as much as possible to avoid getting to the stage where we have to litigate because the standards are relatively clear as we can make them. There may be somebody else who can give a better answer to that question, but that's how I would respond.
Thank you. Are there questions, Representative Luno?
Thank you very much, Mr. Chair, and thank you for being here, Mr. Kinzer, and taking my question. You just Chair Ladd was just touching on page 2, lines 32 through 35, which is the sort of like the catch-all. Nothing in that section, in this section, shall be interpreted as preventing public institutions from prohibiting, restriction of expression. That touches on true threats directed to provoke imminent lawless acts, stuff like that. I was wondering, how come the section on the very next section, J:3, freedom of association and non-discrimination, why doesn't that have the same language?
So my understanding is that those provisions on actually engaging in speech would apply just as much to speech that occurs in the context of, say, some associational event as it would apply any place else. The point of the associational protections is not so much about the conduct of the group once they're recognized. It's really about what's the process for the recognition of groups and what standards can universities have in place that would restrict the ability of a group to be recognized as a student association based upon their viewpoint or the way in which they go about selecting their leaders. And so my reading of the bill is that when it comes to the actual conduct of a group, the way in which its members articulate their message, doing that on campus, the same standards that apply to anybody else with respect to speech would apply. But the associational protections in terms of group recognition are important because there's been a lot of confusion around that issue in universities across the country that's resulted in litigation, particularly around the question of can belief-based organizations require their members to share the beliefs that the organization holds. And courts are more and more in dramatic fashion saying, yes, they can. And the hope of this provision is not to say, once you're recognized as a group, it's absolute carte blanche and you can engage in harassing behavior or criminal behavior at all. Nothing about the association provision protects that. But it does say that the university can't look at your viewpoint as you're going through the process of being recognized and saying, because we disagree with your viewpoint, or because you require your leaders to share your viewpoint, we're not going to recognize you at all. So I think that's the distinction.
So follow up, Mr. Chair?
Yes.
So thank you. So take me through this then. If basically a student organization shall not be, shall not be denied any benefit, and this is the word from the phrase from top of page 3, line 1.
Yes.
Shall not be denied any benefit or privilege available to any other student organization. So any benefit or privilege that could be maybe $500 or $1,000 worth of
potentially student activity fee
financial
funds,
support, maybe a place on campus to
yes, sir,
to conduct that activity, and an organization that where all of its members, and particularly all of its leaders, affirm and adhere to an organization's sincerely held beliefs. What if those sincerely held beliefs were so abhorrent, similar to the questions that were asked of President Gay a few weeks ago down in Washington? Would the university then still have to provide that student organization space as well as financial support on the taxpayer's dime?
So the law makes a pretty clear distinction between abhorrent views and abhorrent conduct. And one of the things that I want to communicate here today is the groups that I'm here on behalf of are, generally speaking, campus ministries whose desire to be on campus relates to hosting Bible studies, being involved in missions projects, being involved in public service. So and those kinds of groups consistently have been the groups that are engaged in litigation over the issue of not being able to be recognized as a student group. If you go out and look at the litigation that's actually happening in this area, it's really not groups with abhorrent views that are litigating because there are all sorts of disincentives to those groups forming in the first place on college campuses. But the thing I want to really stress is that going all the way back to the early 70s during the Vietnam era, the U.S. Supreme Court had to look at a number of cases involving groups that at the time were considered abhorrent. So, for example, at least by some people. So, for example, the Students for Democratic Society at the national level were advocating for the violent overthrow of the government of the United States. And in a case called Healy v. James, this was a case out of Connecticut, a university there had said, well, we obviously can't have a group that's advocating for the violent overthrow of the government of the United States be a recognized student group on campus. That case went up to the U.S. Supreme Court, and the U.S. Supreme Court said, you can't engage in viewpoint discrimination based upon the view they hold, no matter how much we may disagree, no matter how abhorrent we may find it to be. If they engage in conduct that facilitates the overthrow of the United States, if they engage in violence, if they engage in harassment, if they engage in inappropriate conduct, then you absolutely are in a position to act. But to say they can't form to discuss their ideas on a university campus simply because we disagree with those ideas is contrary to the protections of the First Amendment. My point is not to defend any abhorrent group. My point is merely to say that if that kind of situation were to arise, the place that a radical group with abhorrent views would go to try to get protection would not be this state statute. They would go to Healy v. James, a long line of well-established U.S. Supreme Court precedent on viewpoint discrimination, and where I think this particular piece of legislation will actually be useful. The kind of litigation that's actually emerged around this issue of having leadership standards is not the radical group. It really is relatively run-of-the-mill, belief-based student organizations that have had to sue in state after state to vindicate their right to have their leaders share their viewpoints. So that's a little bit of a lengthy answer. I apologize for that. But
yeah, although Mr. Chair, it really didn't address the question. The question is, would these groups, under this policy, under this proposed bill, be entitled to the same benefits and privileges available to any other group, any other student organization? So talking about benefits and privileges such as, here's $1,000 to run your organization, and here's a room in the student union where you can meet. That's different than a group of students that may form a group, rent a house somewhere off campus, and live together and hang out together. But we're talking about where the university financially and through through other benefits.
Well, fortunately,
would be supporting a group, and I don't want to. I'm working on the four corners of the bill.
Understood.
Not the sweet center in the middle that you're talking about.
Yeah. And fortunately, we have some really good guidance from the U.S. Supreme Court on this issue as well. So in Rosenberger versus the University of Virginia in 1995, the U.S. Supreme Court was clear that student activity fee funds, which is what we're talking about here, cannot be withheld from a group merely because they promote or manifest a particular belief system, even if it's a belief system that we would find abhorrent. And again, like so much of this bill, the intent of the bill is to provide clear statutory language that student groups can look at, that administrators can look at, that basically recapitulate what courts have said for a very long time. So again, yes, this bill says that universities, in determining who can be recognized, who can have access to benefits that every other student group gets, won't engage in viewpoint discrimination. But that really is just black letter First Amendment constitutional law. There's many instances where states, I think for good and proper reasons, pass legislation, the intent of which is to essentially implement, provide guidance regarding, provide clarity around constitutional protections. And that's largely what this bill does. It's designed to prevent controversy, prevent litigation by providing clear language on the face of the statute that's consistent with what the U.S. Supreme Court has said about viewpoint discrimination, even against abhorrent groups in Healy, what they've said about student activity fee fund access with respect to viewpoint discrimination in Rosenberger. And so that's essentially my sense of it. We're trying to decrease the likelihood that students are going into court to sue their own universities over issues that never should get to that point because the precedent is clear.
Thank you. We do have a number of other cards here, so if there are no more questions, thank you very much. And
Thank you so much.
Invite up Caleb Dalton. Welcome.
Well, thank you very much, Chairman Ladd, Vice Chair Cordelli, members of the committee. Do you like freedom and liberty? In this committee, that might be a rhetorical question, but it was a real question that students asked on a public university campus just a few years ago. For asking that question and passing out copies of the Constitution without a permit, those students were arrested and they spent the night in jail. The answer on our college campuses to that question shouldn't be no. After all, the Supreme Court has stated the essentiality of freedom and the community of American universities is almost self-evident, even for viewpoints that we don't like. Indeed, our nation's future depends on leaders that are trained through the wide exposure to that robust exchange of ideas, which discovers truth out of a multitude of tongues rather than through any kind of authoritative selection. But many colleges and universities across the country fail to meet this standard. The speakers in that case that I mentioned should not have had to be arrested or to go through litigation to vindicate their rights. Legislation like HB 1305 helps prevent that for students in New Hampshire's public colleges and universities, and it allows them not to rely on the whims of university administrators and policies that may change, but rather to have a baseline reliance in the law. By way of introduction, my name is Caleb Dalton. I'm Senior Counsel with Alliance Defending Freedom. ADF Center for Academic Freedom has been protecting college and university students and faculty's free speech since 2006. We've had over 435 victories for First Amendment matters in public schools and over 15 victories at the Supreme Court since 2011 on behalf of our clients. I appreciate the opportunity to speak to you today and would like to address two brief points. What does HB 1305 do and why does it matter? HB 1305 will protect the constitutional rights of students, and ultimately, if the university is abide by the bill's requirements, as you heard from the prior testimony, it may actually save the state unnecessary attorneys' fees and litigations by establishing this baseline constitutional protections. It doesn't micromanage New Hampshire's universities but it does set these baselines that every institution should meet to protect free speech and free association. And it makes those permanent, not subject to the whims of changes in new staff or administrations at each different institution. This bill simply prohibits prior restraints on student speech while also permitting reasonable content-neutral restrictions, and it ensures student organizations can form around shared values. It allows campus members to speak freely and spontaneously without red tape and unconstitutional restrictions, and it allows them to choose who they join with to speak. Legislatures in at least 20 other states have passed similar bills. The Granite State, with its classic motto, "Live free or die," should join states across the country in protecting its public universities as the marketplace of ideas where freedom, not fear of government restriction, leads to innovation and intellectual flourishing. Why is this needed in a state like New Hampshire that's received a high rating from FIRE? At least two reasons. First, freedom is never guaranteed. It's not passed down in our bloodstream. Absent laws or litigation, it's actually subject to the whims of campus administrations, which come and go. Second, New Hampshire, despite its high rating from FIRE, is not immune from the impositions on free speech and association that come from fears from students and administrators. You heard last spring from students represented by First Liberty, who experienced firsthand the Student Bar Association's discrimination against them and the recognition status that was withheld from them. At Alliance Defending Freedom, I represented students this last year as well, whose organization were charged extra fees to host an event on campus because of fears that others might behave poorly. That's a prohibited heckler's veto, and it is literally expensive speech, not free speech. In conclusion, the status quo at many universities substantially restricts free speech and association, and it teaches students that government censorship is the norm, not the exception. New Hampshire should lead in repudiating this mentality and show that it's not afraid of freedom. It should take a step to secure the future of freedom through a well-educated citizenry that appreciates the value that free speech brings to society through firsthand experience of that freedom on their campuses. Commend the committee for its attention to this vital matter. And before I take questions, I would like to just address one quick matter that was raised by Representative Lanoux. I apologize. On page 2, 32 through 35, if there is any concern that that section didn't apply to the next section, I think it would be very easy to fix that by striking section and inserting chapter. Nothing in this chapter should be interpreted, and that way it would be ensured that that provision applies to all the sections within the chapter. Thank you, and I'm happy to answer any questions.
Thank you very much. Are there any questions from the committee? Yes, Representative Tanner.
Thank you, and thank you for taking my question. What is non-commercial expressive activity? For example, is a campaign considered commercial, political campaign?
I don't believe so.
So that's considered a non-commercial. What would be considered a commercial activity?
So within First Amendment law, there's a definition of commercial expression as that which either engages in an exchange or proposes to engage in exchange of money for value. So it's basically commercial speech. So you're selling something or asking, trying to sell something on campus.
That has an exchange of money. Is that
of value? Some courts have interpreted that to be beyond, so his services. So for example, fundraising. Some courts have said fundraising, even for a nonprofit, for example, that's not considered commercial, but they've said that is commercial speech. So I think that and some courts would fall under that.
And my second question is the last particular section on page 3, 27 through 30, the severability. Whenever I see that, I always think that there must be something in this bill that could possibly be unconstitutional. I was wondering if you could point out any section in this that is particularly in line for litigation or that could be declared unconstitutional that hasn't been already.
I don't think there is any provision in this bill that could be declared unconstitutional. It basically reiterates the lines that courts have laid down over the decades of what does the Constitution allow universities. So it sets that baseline of what courts have already said is the law. And that's one of the reasons there's benefit to passing it, is it sets that baseline so it protects the state from litigation in the future by saying, hey, we're going to follow this baseline. And that way you don't have to fear litigation in the future because you've already set that baseline established by the Constitution.
May I have a follow-up to that? Just
Be a third question. So if this is it, yes, go ahead.
Okay, 3 strikes and I'm out. Okay. So why put in the severability law? Is that some of this has not been challenged in court before?
So severability, my understanding, is generally included in most legislation, to my knowledge, but I'm not a drafter of legislation. So I frankly don't know any provision in this that would be subject to a constitutional challenge.
Okay, thank you.
Thank you. Are there other questions from the committee? Yes, Representative Ford.
Thank you, Mr. Chair, and thank you, sir, for taking my question. As a former university president, I've been present at a lot of demonstrations in which there were activities which were perhaps by local or state law illegal, speaking specifically smoke-ins. And does the freedom of expression addressed in this law continue to the point where it enables people to legally conduct a smoke-in, a marijuana, against the laws of whatever may exist? Is that legal?
I don't think so. That's conduct, not expression. Now, it may be there are a few cases where, somebody's argued, oh, well, my conduct is to express a message, right? And maybe that's an argument someone could try to make, but I don't think under this statute, it's because of somebody's viewpoint, not because of their conduct. So if a prohibition on smoking, for example, is a content and viewpoint neutral prohibition, and this law specifically allows for that type of regulation. As long as it's content viewpoint neutral, it's not targeting smoking, for example, or a viewpoint of marijuana legalization, right?
Right.
It's just the conduct of smoking that could absolutely be prohibited under my interpretation of this bill, for sure.
Awful lot of college dorms are illegal at the moment.
Okay, we'll move on here. Are there any other questions? Thank you very much. I'd like to invite Greg Gonzalez. Welcome again.
Yeah, thank you. Nice to be back. Chairman Ladd, Vice Chairman Cordelli, and members of the committee. My name is Greg Gonzalez, and I'm Legislative Counsel for the Foundation for Individual Rights and Expression, also known as FIRE. I'm here in support of HB 1305. This bill guarantees crucial First Amendment protections at New Hampshire's institutions of higher education. First, the bill would designate outdoor areas of campus as public forums. This would effectively ban so-called free speech zones, which are often small, remote areas that impermissibly quarantine expressive activity to isolated areas of campus. Over 20 states have already enacted laws to ban these so-called free speech zones. Further, this bill helpfully and carefully defines the line between constitutionally protected protests and unprotected hecklers' vetoes. New Hampshire's public institutions of higher education have maintained policies in the past that severely limited students' speech rights. For instance, the University of New Hampshire had a policy in the past that required student organizations to get their flyers and pamphlets they sought to distribute pre-approved by the campus police chief. That blatantly unconstitutional policy was on the books for some time. Thankfully, after working with FIRE to revise those unconstitutional policies, the University of New Hampshire now receives FIRE's highest green light speech code rating, meaning it has no speech codes that seriously imperil free speech rights. I'm also happy to note that UNH ranked third out of 248 colleges in FIRE's 2023 college free speech rankings. Now is the time to statutorily lock in these speech protective policies. Last year, much of the discussion centered on whether this bill was needed. If UNH is doing so well, why is a law needed? I think in the last few months it has shown that commitments to free speech by university administrators, unfortunately, can ebb and flow. Many administrators have had difficulties making clear to their campus communities what is acceptable and what is not, oftentimes facing outside pressure to crack down on unpopular speech at their institutions. At public universities, including at UNH, commitments to free speech should not change at the whim of whichever administrator is currently in charge. Instead, it is imperative that this legislature lock in free speech protections into law. The bill also aims to remedy the threat to freedom of association created by the Supreme Court in CLS v. Martinez. In a sharply divided 5-4 decision, the court held, despite its own long-standing precedent upholding freedom of association, that a public university may require its student organizations to accept any student as a voting member or leader, regardless of whether that student openly disagrees with or is even hostile to the group's fundamental beliefs. College Democrats should be able to require that its members be Democrats, and the Muslim Student Association should be able to exclude from its leadership those who oppose Islamic teachings. FIRE's view is that the campus community is made more vibrant when belief-based organizations are able to organize and unite behind their shared beliefs. Lastly, I would like to note something that was said earlier with regard to the truth threats and then the incitement standard. So that's the standard that's mentioned in the bill is the Supreme Court standard for incitement in the Brandenburg case. So that's why that language is in there. It could just say incitement, but it just says the test right there. So that's why it's in there. But yeah, in conclusion, FIRE supports this legislation, and I welcome any questions you may have.
Thank you. Are there questions? Yes, Representative Tanner.
I just came and I am taking over questions. Thank you for taking my question. On these free speech bills, I've always been wondering about the fact that if I am a student, and I was a student, and paying, dearly for my room on campus in a dormitory, I used to, they would have prank fire drills, and that used to bother the heck out of me. But those people were taken care of. But with these, protests anywhere on campus, do I have a right to my privacy as paying for a dorm space where I want to study and I want to sleep from having a protest outside my window at 2 a.m. or 1 a.m., that sort of thing?
Thank you for the question. Yes, you do. So laws can have these these time, place, and manner restrictions. So as long as they're content viewpoint neutral, those types of laws would be constitutional. So as long as all types of kind of expression was prohibited at those times, then yeah, of course those would be constitutional. You would get into problems if you said, well, from from noon to 1 you can only have this, you can have any type of expression you want, and then from all other hours you can only have viewpoints we agree with, something like that. That would not be viewpoint neutral, right? So as long as those time, place, manner restrictions are viewpoint neutral, usually there's not an issue.
Thank you. Any further questions? Yes, Representative Luno.
Thanks very much, Mr. Chair, and thanks again, Greg, for taking my question. Of course. Going back to the freedom of association part, did the Supreme Court, U.S. Supreme Court, weigh in on whether that freedom of association extends to receiving the same benefits and privileges, meaning financial support, the $1,000 from in public tax dollars, and location to set up shop, maybe in the Memorial Union building, as any other group?
So yeah, as the previous witness mentioned Mr. Kinzer, who speaks very eloquently on these subjects, even more so than, well, definitely more so than myself. You know, the relevant case is the Rosenberger case, and yes, you know, if certain benefits are open to groups, that, you know, you can't discriminate based on discrimination. So you can't say, you know, obviously the easy one, you can't say college Democrats get, you know, all the space in the world and Republicans have to stay in the, you know, in a corner somewhere type thing. So as long as you have that, if you're opening those benefits up to student organizations, you have to make sure it's done on a neutral basis.
Thank you.
Further questions? Thank you very much.
Thank you.
I'd like to invite James Tebow. Jim? Okay. Okay, next one is Jacob Coughlin.
Thank you, Mr. Chairman, members of the committee. My name is Jacob Coughlin. I'm from Derry, and I'm here to speak in favor of the bill. I'm not a politician. I'm not a lawyer. I'm a freshman in college. So let's get that out there first. But I've tried to organize different groups in my community and at school. And at UNH Durham, I ran into many issues with campus administration where they would do everything in their power to prevent me from organizing there, whether it be calling them for days on end or sending emails in an extensive administrative process. They did everything in their power to prevent me from, you know, organizing like-minded students, which in my opinion is an issue for anyone in New Hampshire. You know, it's not a Republican issue or a Democrat issue. So, I mean, that's all I'd really like to address. You know, it was very difficult to organize. They did everything that they could to stop me, whether that be requiring a permit on public land and things like that. Thank you.
Thank you. I have a question for you. What were you trying to organize?
I was just trying to organize volunteers for for a few events. That's all. Nothing really crazy.
Can you explain the events, the purpose?
Yeah, just free speech events with different political organizations. So, for example, we wanted to organize people for the Americans for Prosperity, for other groups like that as well. Just general free speech stuff.
Further questions? Yes. Well, Representative Lucas and then Representative Luna.
Thank you for taking my question. Were you eventually able to have those events or not?
Yes, I was, but we had to go through a very extensive process. In my opinion, it seemed almost like they were doing everything in their power to legally prevent us from being there. Again, that's my opinion, but yeah.
Okay, thank you.
Representative Luna?
Scary, but I must have been reading Representative Lucas's mind.
Psychic. Representative Peternell.
Thank you, Mr. Chairman, and thank you for being here and exercising your freedom of speech to come before our committee today. Do you know of any other organizations on the University of New Hampshire campus that have had trouble organizing? I seem to recall an incident, I believe, from maybe about a year ago.
I'm not familiar with any, to my knowledge, but all I do know is my own personal experience where it took a lot more effort than frankly it should in America to organize, you know, a group of people to act in a political fashion. Yeah.
I do have another follow-up question then. Do you know if there are other organizations that had to go through the same process as you had to go through, or were you being discriminated against?
I'm not familiar with that, but in my opinion, I feel like I was being discriminated against based on our viewpoints. We had campus administration be very very aggressive with us, trying to prevent us from organizing, threatening to remove us from campus before we had a permit, even though we were on public land. doing a First Amendment protected activity. So, yeah.
Thank you. Yes, Representative Damon?
Thank you, Mr. Chair. Thank you for being here. Could you tell us in more detail, what was the timeline between when the process began for you to have your events happen, and what were the expectations of what you needed to do to be approved?
So I had to call multiple times, campus security, campus administration, calls, emails, things like that. Frankly, I don't remember exactly how long the process was. Ballpark 5-6 days, maybe a week. And it wasn't a holiday week or anything like that. It wasn't Thanksgiving that we were trying this. So I don't know. It was lengthy. There was definitely a lot of hoops to jump through that felt, frankly, unnecessary for, again, a First Amendment protected activity on a public college campus.
Yes.
What was the size of the event in terms of the expected number of individuals?
So it was just setting up a table with 2 people and asking people to volunteer for us, or to come to our events. So it wasn't like we were creating a scene. We were next to a walkway, just talking to people. So it wasn't necessarily like a large deal, right?
Representative Belcher?
Thank you, Mr. Chair. And thank you for being here and for your testimony. I think candidly, we can say that there are considerable political divides in this country. And that is reflected in college campuses. We've seen that. So my question to you is just a very general sense. Is it your belief and understanding that all groups, regardless of what side they're on or their viewpoint, are currently treated the same by the university?
Personally, I don't think that we're all treated the same. I feel like if I was there advocating for abortion or a different, I guess, more left-wing social cause, I would definitely be in a poor position, or sorry, better position than where I was then. I mean, honestly, arguing for a more conservative standpoint or viewpoint at university where it's so overwhelmingly and obviously liberal, it's really a tough position to be in. I mean, and of course, the university can't outright reject me because of my opinion, but they definitely did everything, in my opinion, in their power to prevent me from speaking my mind and organizing and doing other First Amendment protected activities.
Thank you.
Representative Luna?
Thank you, Mr. Chair. When you mentioned that you received some, I guess, had some interaction with university personnel during events. Were you in violation of any particular freedom of speech policies?
To my knowledge, or at least to my knowledge at the time, no.
What about your knowledge now?
Apparently, we required a permit. I'm not sure if we actually did, to be totally honest, because it was 2 people setting up a table, and in my opinion, that falls under the First Amendment. But they confronted us. Hey, you need to get a permit to set this table up. They tried to make us move locations. They were as difficult about the process as possible.
So follow up, Mr. Chair?
Yes.
So my understanding is that UNH is, ranked 3 out of 248 institutes of higher education with respect to its freedom of speech policy. So it likely has a policy that consistent with this bill may maintain and enforce reasonable time, place, and manner restrictions. And were those the restrictions that were being imposed upon you now that you are more familiar with the policies?
I'm not necessarily sure, but I also don't see how 11 a.m. next to a footpath on the campus of a public university is really in violation of any reasonable expectation of making a public disturbance. We weren't making a scene. We weren't doing anything really confrontational or terrible in that regard. We were there with a table asking for people to volunteer for us.
Okay, thank you.
Any further questions? Thank you very much.
Thank you.
Okay, I'd like to call forward, let's have the university system up here now. So if the chief wants to come with you, Chad, that's welcome.
Hello, everyone, and thank you for the opportunity to testify. For the record, my name is Chad Pimentel. With me here today is Chief Paul Dean, who is the Chief of Police for the UNH. We have written testimony that will circulate here when we're finished. Candidly, it's essentially exactly the same thing that we did last year. So rather than read it back to you again, I propose to go a little more narrowly and to address some of the things that I've heard from the other speakers so far. The first is that this bill is designed to use language that courts are familiar with to reinforce existing limitations on what public universities can and can't do around regulation of speech. And the university system has some concerns about whether or not that's correct. So, for example, on page 2, at line 25, right before that, there's the language that some other folks have referenced saying that reasonable time, place, and manner restrictions are allowed. But the next sentence at 25 says that any such restrictions shall allow members of the campus community, which, as defined in the bill, includes not just students, faculty, and staff, but also their invited guests, which I'm not sure how Chief is supposed to determine who's an invited guest and who isn't, but it's a very broad definition, that those folks will have the right to spontaneously and contemporaneously assemble. One of the most basic time, place, and manner restrictions that are employed by public institutions are permit processes. As I read this, essentially it's taking our ability to require a permit out. And so I struggle how to reconcile that with the idea that it preserves all reasonable time, place, and manner restrictions that are otherwise available to us. Chief Dean, his office is very deeply involved with the permitting process. I wanted to just briefly pause and let Chief explain how permitting works at UNH. I'll just say from a policy perspective, maybe the most important thing is it says in the policy that the presumption is that permits are to be issued. We start with yes. We don't look for reasons to say no, but Chief can perhaps say more.
Thank you. I appreciate this opportunity to address you on the importance of free campus permit process. And I want to underline free. There's no cost to this permit. In maintaining law enforcement and public safety on campus, the issuance of over 300 to 350 permits each year without complaints underscores the effectiveness of our current system. The UNH Police Department believes that existing permit system coupled with UNH policies effectively educates both on-campus and off-campus individuals about acceptable behavior. The dual approach ensures parity in educating the community about what is deemed acceptable behavior before an event occurs. By doing so, we contribute to the de-escalation efforts, reducing the likelihood of confrontation that often require campus police or public safety intervention. The permitting process serves as an educational tool and means to encourage dialogue about behaviors that may disrupt campus functioning. It is not meant to limit free speech, but rather enhance it by fostering discussions on acceptable conduct. The process allows off-campus individuals to be forewarned about potential disruptions, facilitating an environment where conflicts can be avoided through education and discussion. The UNH Police is committed to maintaining a positive relationship with the community at large. However, the ambiguity and uncertainty introduced by this proposed law risk placing the police department at odds with the community, as enforcing a poorly defined law can lead to increased tensions and potential legal challenges. Attorney Pimentel's concerns about the law and the ambiguity leading to unnecessary lawsuits is valid, and I share his concern. In summary, the UNH Police supports no-cost permitting process. that focuses on education and de-escalation rather than limiting free speech. The current system effectively balances the need for public safety with the university's commitment to fostering an environment of open dialogue and expression. Clarifying the definition of materially and substantially disrupts in the proposed bill is essential to ensure that the law aligns with principles that do not create unnecessary conflict.
And if I would just try to boil that down even further, I think I would describe how Chief and his folks administer the permit process is trying to use a pretty good dollop of common sense in balancing, giving folks access to campus, letting them exercise their rights, but not unnecessarily exercising the campus community, not possibly running up against violating campus policy or law, such that the event can go off, people could have their speech, and the university continue to function. Chief also mentioned one of the other pieces of the bill that I wanted to highlight, which is the notion of a material and substantial disruption. That is a phrase that you see in court cases. It's used to describe a public educational entity's ability to take action against a speech and conduct event that has gotten out of control. We're not required under the First Amendment to allow actions that disrupt our operations. So that phrase is a phrase that comes out of well-understood court cases. However, that's not how it's used in this bill. The phrase materially and substantially disrupt is defined in this bill at page 1, starting at line 13, in a much narrower way than courts usually use it. It talks almost entirely about what is usually called the heckler's veto, which is when somebody else comes onto campus and does something that prevents somebody in the community from exercising their right to free speech. The right to, in general, the right of an educational institution to prevent disruption isn't just limited to occasions when a heckler comes on and tries to disrupt an event. What if what's being disrupted is not somebody else's speech, but it's a nursing class? What if what's being disrupted is a counseling session? Under the First Amendment, we do retain some discretion to act in those situations. Again, Chief and his folks use a good dollop of common sense in that, and making sure that rather than shutting things down, we try to make sure that people have, are able to express themselves in other ways in other places if necessary. So again, the system struggles to reconcile the idea that this bill just clarifies and restates existing law with the notion that the fact that it appears to restrict us from using some reasonable time, place, and manner restrictions, and it uses some language in unfamiliar ways. And whenever you've got unfamiliarity or ambiguity, how it all ultimately gets decided is in litigation. And litigation has a huge cost in terms of money and time for the system. I should also just finish by saying we've expressed, Representative Popovich-Muir has been wonderfully available to us, and we've expressed sort of these concerns and additional ones. We circulated to him a proposed markup that we thought could address some of these challenges. I don't want to go through the entire thing here because I want to be respectful of folks' time and also their bladders. So I'll pause there. I'm happy to answer any questions that folks have, and Chief may chime in as well in his areas of expertise.
Thank you very much. And this first one's for both of you. Invited guests versus uninvited guests. Hecklers could be in both of those groups. How do you deal with the uninvited types that are seen at one protest after another throughout this country that all of a sudden arrive on your campus? Is the permitting process set up to deal with this type of activity?
So the permit will be required of the organizer. Presumably a heckler is coming in to disrupt that. They ought to be separately requesting a permit. I take your point that many times they wouldn't. As for how it's managed, Chief and his team manage that issue with respect to very large events all of the time. Obviously, just recently, former President Trump came and rented out the Whittemore Center, had an event that obviously had a chance for disruption. Chief and his team managed it. There was no disruption. I think they, again, have pretty good common sense processes in place to address that. To your point, though, Representative Ladd, of how do you determine who's invited and uninvited for purposes of determining who has additional protections under this bill, I think would be very challenging.
Thank you. Questions from the committee? Representative Belcher, and then Representative Cordelli.
Thank you, Mr. Chair, and thank you for being here. You brought up an interesting point about the time, place, and manner restrictions, excuse me, as it involves the permitting process that you currently have. I'm sure most of us are aware there has recently been a number of rallies, protests, vigils, other such things, group gatherings on the UNH campus, some of which have made news headlines. I'm not here to take any position on the individual speech. They have that right. But my question to you is, were all of those events permitted events by the university?
I'd say that I don't have details on that. Chief, do you?
I'm not sure about all the events you're talking about, but I think the ones that you are talking about do have a permit, and the permits are free. There's never been a no. I've been a policeman for 39 years, 34 of them at the university. There's never been a no to it. It's always meant to educate, to make sure on issues such as how do you get electricity if you need to use a megaphone? How do you, if you want to put something in the ground, you have to use DigSafe. That's a law. We talk about littering, making sure that they know they need to pick up their things. So that's the educational aspect of those. The other part to that is I have a limited police force. And so I need to know how many people are going to be on our campus so I can provide public safety services or bring in more people for that. So the permit process informs. But when it comes to those I think you're talking about, they were permitted. But I'm not sure of all of them that you're talking about. But if they came to us, they would have been permitted.
And if I may, a quick follow-up on that, and thank you, that does help. So obviously, it's great that the permits are issued freely and they're not turned down. But we also have to look at the possibility, which as we've heard elsewhere, that there is some perhaps unequal enforcement happening of non-permitted events. So in order to assess that and do our due diligence as a committee, would it be possible to say, receive a copy of permit records that have recently occurred so we can compare that to media reports?
Sure, absolutely.
Thank you, I appreciate it.
Further questions from Representative Cordelli.
Thank you, gentlemen, for being here. I believe it was mentioned about the definition for materially and substantially disrupts being unfamiliar based on other court decisions and so forth. Could you specify what in particular in this definition causes you a problem?
It's the narrowness of it. It's the fact that the only activity that seems to be defined as materially and substantially disruptive is our actions that disrupt someone else's speech. There's nothing that goes to disrupting the actual business of the university. And there are cases dating back to Tinker in 1968 that stamps the proposition that educational institutions can take action to prevent actual disruption on their property.
Last year, we had, I think, the same bill coming before us. I don't know if there are specific changes, maybe some dealing with the costs, but did you have an opportunity during the year that we've had here to try to address those concerns you've had? And is there any way to amend this to incorporate the concerns that I see a hand up down and back from the representative? Okay. I think I'll get my answer, but go ahead.
I think it's right. The answer, again, he's been very available. We did meet with him. We did send around some proposed changes. Obviously, the bill is his to submit to CC's fit.
Okay, great. Further questions, because the next one which you're going to invite up is going to be the prime sponsor of the bill. Valerie, you have a question?
It is not a question, but James Tebow has arrived. Could you please re-add his name to the list of speakers?
Okay, James is back in here? Yeah.
Thank you.
Okay. Okay, so are there any more questions for the university system? Thank you very much.
Thank you.
Thank you.
So we'll skip and get James up here right now, Tebow.
Good morning, Mr. Chair, members of the committee. My name is James Tebow. I'm the chair of the New Hampshire Legislative Youth Advisory Council, which is a statutory committee of the legislature under RSA 19K. I'm here on behalf of the council to express my support for HB 1305. I think we all agree that it's very important that we ensure students' free speech rights on college campuses. But I'm not so much here to talk about the merits of the bill because I feel like many of the other speakers have already done that. I'm here to kind of talk about what the bill is lacking, and that is representation and protections for high school students. So I'm speaking on this as a high school senior myself, who has dealt with freedom of speech suppression at my school. During the summer of my sophomore year, going into my junior year, I wanted to establish a chapter of Young Americans for Freedom on my high school campus. And my high school principal said that he did not want to approve the organization because he feared that it would make people uncomfortable. And I got him on tape saying that, and we threatened a lawsuit against the school under free speech grounds, and we ended up getting the club established. However, with the current foundation of federal law that exists under, I believe, U.S. Code 4072, it's called the Equal Access Act, and it basically says the school is allowed to impose restrictions on student organizations as long as those restrictions are evenly applied. So they told us that we could only have one poster on school grounds. We could not advertise via email, via school announcements, or any of these things that typically clubs are allowed to do on campus. And they said they could do this because they were also going to start applying those restrictions to every other club on campus as well. And they also strung out the approval process for my club by 6 to 9 months. So because there are none of these protections in place for the actual establishment of these organizations, it essentially suppresses speech. And it's, I think, blatantly unconstitutional. And but they're allowed to do it because of the particular way that the law is written. So we would like to encourage the committee to either amend this bill or bring forward a new bill to also address the concern of high school free speech suppression as well. And I'd happy to take any further questions on that regard.
Thank you very much. Are there any questions from the committee? Not seeing any hands. Thank you very much for coming today.
Yeah.
I'd like to invite Ellen Reed.
Thank you, Mr. Chair and members of the committee. I'm sorry for my anxiety. I am running late for work. And actually, I am supposed to introduce the following bill, and I have managed to get Representative Hill to do that for me on behalf of Cam Kinney. So I'm just going to speak conceptually. I'm not going to have time to take questions, but I was here testifying for a substantively similar bill last year, and I believe I opened my testimony last year with a statement to the effect of, now why would a far left socialist, self-avowed atheist be speaking in favor of a bill that's primarily supported by conservatives and religious people? And what I said then is what I still believe, which is free speech is inherently a liberal notion. John Locke liberal principles is a founding of our country notion, and it is historically a progressive cause. And if you need evidence, look no further than the protests against the Vietnam War on campuses where at least 4 students lost their lives. Look no further than the civil rights movement and the protests there. And what I said then is that somebody has to be the adult in the room because the winds change. What is popular opinion today may be unpopular opinion tomorrow. And while today it may be the popular opinion to have liberal notions and conservative opinion may be unpopular, I am unwilling, even though that benefits my talking points, I am unwilling to risk freedom of speech because tomorrow it may be the other way around. And what I could not have predicted last year when I testified to that effect was how quickly the winds have changed. Because today, one of the most, as you all know, controversial topics on campus is the situation in Gaza. And what is the definition of a justified act of retaliation versus oppression? What is colonialism? What is genocide? These questions are coming up, and now it is the unpopular leftist opinion that is being threatened in many scenarios. perhaps not all the way across the board, but certainly that is of something that's weighing heavy on us today. So I continue to believe, as I did then, that the way we overcome bad ideas is to not oppress those bad ideas, to not suppress them, because that gives a talking point to the people with those bad ideas, that they weren't allowed to say what they had to say and they were unjustly being restrained. And now I probably don't agree on a whole lot with the people who are advocating for this bill. But I will say that I need my free speech protected, even though I'm not planning on going back to college. I need my free speech protected, and so therefore I believe in protecting theirs. So I guess I'll wrap that up. I can only speak conceptually. I understand this bill has had some minor changes, whatever you see fit, but I just want to advocate as the token leftist in the room for the concept of the bill. And I apologize, it's not like me to not be able to take questions, but I really need to go to work. And again, thank you for Representative Hill introducing the next bill.
Thank you, and good luck getting work. Lastly, we will have the prime sponsor, Representative Popovich Muller.
Thank you, Mr. Chairman and members of the committee. I really appreciate your time, and I'll do my best to be reasonably brief under the circumstances, which may not be quite brief. We already spoke about this bill last year, and a lot of those things apply, so I'm not going to repeat everything. I just want to remind you that I was born and raised in a communist country and experienced the lack of freedom, which leads to me appreciating freedom a bit more than people who never experienced the opposite. I also want to remind you that I've been involved in education one way or the other my entire life. My mom was an elementary school teacher. I taught for a living for a decade. I served on the school board. I'm serving on finance too, dealing with the state education budget. I am one of the people who truly understands education, and again, the value of freedom of speech and association. This is a nonpartisan bill. Its only intent is to assure that everybody gets equal protection under the law. I don't care which side people are on. I don't care whether I agree or don't agree with them. I think all speech deserves to be protected, because when we start picking and choosing which speech deserves protection, we are opening the door to our speech being on the naughty list somewhere down the road. So we need to protect speech for all groups, whether we agree with them or not. I am a consensus builder. I believe in working, to try to get a general agreement. I have approached this in a very cooperative way. I started engaging with the college systems since late 2022, and we've been in contact ever since. We made a lot of progress. We all agreed with the goals of this bill. We are still arguing about various language items, but nobody in this room, as far as I could tell, disagrees with the premise of this bill. We were almost there last spring when I was told that if I just make one or two minor changes, the bill would be ready to be approved by the universities and get broad bipartisan support. Unfortunately, when we sat down last summer, the red line I received from UNH, which I believe there are copies of it in the room if you want them, required extensive changes that were much more extensive than I expected, and therefore we couldn't really agree on the language. As a result, I decided to fill this bill using the 2023 language. It's pretty much exactly the same as HB 516, with two minor changes. One, the committee noticed that we were inconsistent in using student organization. We used two different terms for it. The bill has been cleaned so that only the word student organizations are used. And I added a change limiting the amount of damages that can be awarded to $20,000 to protect the university system from financial risk. Other than that, it's really the same bill. As I reminded the university system representatives this morning, I do remain open to amending the bill, especially since this is a two-committee bill. It has an FN. In the most optimistic scenario where we pass it, which still has to go through the House floor twice, it has to go through here, it has to go through finance. I will continue to engage to see if I can make the bill better, even if it doesn't get to the point where they are comfortable, supporting it. At least I want to make it more palatable to them. So I will continue to work with that until, the end of the session. And frankly, if it doesn't pass, I'll continue to work on it until it passes. Now, a couple of things that the bill is intended to deal with. First, the bill prohibits free speech zones. Free speech zones are essentially a word that is used to describe the ban on free speech in most areas of the campus that a lot of universities are using. My daughter graduated from RPI and got to experience firsthand the chilling effect of free speech zones. The bill is also designed to decrease the amount of times when students are denied their rights and then they have to go through a lengthy appeal process and retain legal counsel to finally get a resolution. I want to give credit to the university system for being quick to resolve these issues once they escalate through that process. But frankly, if this bill was passed, there would be way fewer times when this will be needed. I don't want to be cheesy and quote Martin Luther King for no reason, but he did say that the right delayed is a right denied. He was using it in a very different context, but the principle still applies. If we make it amazingly hard for people to exercise their rights, we are infringing on their rights, because there are few people who have the courage to hire lawyers and go towards the university threatening legal action. Most people will just want no trouble. They'll just comply and move on. We really shouldn't allow that to happen. The bill also clarifies that no content-based restrictions on speech are allowed outside of a few narrowly defined situations. Obviously, this is already known from court decisions. The Congressional Research Service has a January 10, 2023 report stating that the Supreme Court recognized that laws restricted or compelling speech based on the content have the potential to expel certain ideas or viewpoints from public debate. So the court typically regards such content-based laws as presumptively unconstitutional. It's based on Reed versus Town of Gilbert in 2015. I've heard reasonably often that, hey, if there are court cases already, why do we need a law? Going to courts is a tricky thing. A lot of people cannot afford to go to courts or are afraid to. And frankly, you never know what a court will do when you go to court. And I'll tell you stories in the hallway if you want to know why I feel that way. I don't want to take the time of the committee with that. But it is better to avoid the need for litigation, and this bill is designed to avoid that. Also, college students are adults. They are not, K through 12 students who are minors and deserve a different level of protection. They are all legal adults, or the vast majority of them. So are the staff and the faculty. They have the maturity and skills to handle hearing speech they disagree with. Claiming otherwise, honestly, it's offensive to me, because it implies that somehow our kids graduate high school without the ability to, reason and figure out who's right and who's wrong. We've already heard that this year reminded us how important it is for all points of view to be expressed, whether we agree with them or not, so I'm not going to go over that. To summarize the freedom of association part of the bill, it does really one thing. It states that student organizations must be allowed to choose who can be a member and be allowed to enforce their codes of conduct. The point of this language is to disallow all commerce policies, which have been found to be constitutional by courts, which frankly kind of ruins the trust I have in the courts, because I have no idea how somebody can say that your freedom of association is respected if when you want to associate with somebody, you have to associate with everybody who wants to associate with you. If I have a chess club, do I really have to admit people who hate chess? Obviously, I'm choosing innocuous examples here, but how could it be that we have a freedom of association when we don't get to choose who we associate with? And that's really what all commerce policies do, and this is why I think they need to be taken off the table. I will give credit to the university system and state that they clearly told me they don't have them and they don't plan on having them anytime. I just don't think they should be on the table just in case that position may ever change. I think it's our job to make it clear that's not okay. Now, to quickly touch on a couple of concerns raised earlier. there was a question on severability clause. That's just general language. We don't expect any parts of this bill to be stricken out, but since you never know what courts do, having that type of clause is just good practice in writing laws, because it assures that only a portion of the bill will be struck down instead of the whole thing if such a clause would be missing. In regards to disruptions to the campus as a result of free speech, again, the restrictions are defined in 188-J, column 2, Roman numeral 2. They have to be clear, published, content and viewpoint neutral, and provide ample alternative means of expression. The existing policies do that. This just codifies the requirement that any future policies do the same. There was a question in regards to 188J24, which is the part of the bill that says that nothing in this section shall be interpreted as, preventing public institutions of higher education from prohibiting, limiting, and so on and so forth. I would be more than happy to amend the bill to clarify that that applies to the entire bill, not just to a specific section. That was the intent, and I thought that where it was placed, that was clear. If there is any confusion over that really applies, I'll be happy to reword it slightly and move it out of that section and put it at the end of the bill, make clear that it applies to the entire bill. That's just easy housekeeping. And I will be happy to continue to engage with UNH over any issue, but obviously one of the ones that was brought up today was the permitting issue. I want to work with them to see how we can help them continue to do their job, to require a permit for large events or in situations where a permit is needed, while at the same time trying not to unnecessarily burden tiny little expressive activities from requiring a permit. And, we seem to have a lot in common there, so, I will continue to work on that. One quick thing. This hearing was scheduled on January 9, and the announcement was made on Friday, and as a result of the really unfortunately short notice, some of the people who wanted to testify weren't able to make it, and that is just how the calendar works. I understand that not everybody can get a lot of heads up. But since the bill is basically unchanged, I would appreciate it if you would take the time to review last year's testimony, since it is clearly still applicable. It's on the General Court YouTube channel. The hearing was on February 24th of 2023, and the relevant portion starts at 3 hours, 59 minutes. Now, to conclude, I firmly believe that CCSNH and UNH are deeply committed to respecting the freedoms that the bill is designed to protect. The purpose of this legislation is to provide a clear framework that would benefit everybody involved, state residents, students, staff, the institutions themselves. And I do expect that the passage of this bill will lead to financial savings due to avoiding litigation and, reduced administrative costs. And I do hope that it will earn your support. And obviously, I'll be happy to answer any questions.
Thank you very much, Representative. Are there any questions? Yes, Representative Luno.
Thank you very much, Mr. Chair, and there was no doubt in my mind you were going to be bringing this back because you said so, yeah. and pretty much without any changes. But going to obviously, I've spent a little bit of time and actually quite a bit of time talking with you about the provision for freedom of association. And yes. I guess question to you, Dan. Do you believe that taxpayer dollars or student activity fees should go to support student groups that promote views like genocide?
I do not approve of genocide.
That's not what the
obviously
question is.
But I didn't finish yet. I do not approve of those points of view, but I do not believe legally we have a right to choose which organizations receive those funds or not. They have to be treated equally. That's why the quote from the Supreme Court on the content-based restrictions. When we talk about free speech, the free speech that deserves the most protection is the one we strongly disagree with. I can give you my list of people whose speech I really hate hearing, but those are also the same people for whom I will continue to fight for their right to express those views, because without them being allowed to express their views, neither of us will have a right to express our views once we start going down that path. So I don't think there is any legal way to prevent those benefits from being given to all organizations if we intend to respect our Constitution and our existing court precedents, including the Supreme Court.
So a follow-up on that, if I may. So given that response, then, would it be fair to conclude that your position would be that a student group that advocates for genocide would not be in violation of any sort of student ethical standards? Or
Regardless of how much I would disagree with their points of view, when we talk about free speech, the Constitution is clear, the Supreme Court rulings are clear. There is no wiggle room there. And that is the painful part of free speech. Representative Lu know that. In order to protect our own free speech, we have to protect everyone else's, including people who we amazingly strongly disagree with. There is no alternative.
I just want to make sure I'm clear on that. The question wasn't about free speech. The question was about association. So a group that associates would receive a student association that advocates for genocide, in your opinion, based on your answers, would receive taxpayer or student fee-based funding from the university system, potentially a room at the Memorial Union Building, and not be in violation of any student ethical standards.
I do believe that probably their ethics would be very questionable, whether if they would argue for such a
I'm talking about
position.
the institution's guidelines for student.
Guidelines, I would like to understand if you are talking about policies or guidelines. Guidelines in my mind are
policy.
right. Policies that attempt to regulate the content of free speech are likely anti-constitutional if they are based on content. So regardless of how vile it is, and obviously you chose a particularly vile topic to ask about because you want to highlight the more extreme views that may happen. There is no wiggle room in the Constitution as long as those are just views. If those are actions, obviously they are violating every kind of law there is. But if all they do is hold views we disagree with, then yes, their views should be permitted and they should be treated the same way with everybody else. Now, mind you, universities being a place of higher education, I absolutely expect universities to use the potential that such views may be expressed as a great opportunity to teach their students on why such views are so vile, while at the same time they have to be tolerated. It would teach the students both the importance of respecting the Constitution, and also give them the tools to reject those horrific points of view. Because here's the thing, I come from a communist country, right? Indoctrination was tried really hard, and there was no alternative schooling system or anything. You had to go to the same schools who taught you the same nonsense, and I could rhapsodize for hours over the political science and all those fun topics they taught. At the end of the day, people know what's wrong. But the only way for them to confront it and be able to reject it is to be allowed to hear it in the first place so they can react to it. It's like keeping kids in a bubble and they never develop antibodies. To develop those antibodies, to develop the ability to reject those horrific points of view, yeah, you do have to occasionally hear them as words, not as actions, and be able to react and explain, talk back and explain why they are so horrific. Talk to other people who may have heard them. Those are educational opportunities. If we try to hide our kids from speech they may find uncomfortable, we are doing them a great disservice. And we are, in my opinion, failing as an educational institution, because we are missing on all those opportunities to teach them how to handle. Those people are already out there. If you hide them, you just let them speak in the corners where nobody can confront them. Go ahead.
So, Mr. Chair, I mean, I'm really talking about association, but you keep going back to speech, and so I picked a a condition that's clearly abhorrent and a real edge case. for association. For speech, genocide would probably fall under true threats expression directly to provoke imminent lawless actions and likely to produce it or producing harassment as defined in the RSA. And I'm reading from page 2, lines 32 through 35 of the bill. So it doesn't sound like this bill would allow for free speech of what I was talking about, but it would allow for association of groups sponsored by the university for that espoused views such as genocide.
As long as espousing those views does not break any laws, the university would have to accommodate all student associations equally. Yes.
Thank you.
Yes, Representative Cordelli.
Thank you, Representative, for bringing this bill back. I was wondering if you recall, a month or two ago, there was a pro-Palestinian demonstration on campus. It received considerable attention. I think there was even on some national news reports. And it was objected to by many Jewish students, specifically for chants of "from the river to the sea," which some people say is calling for genocide. The university's position was that it was First Amendment, freedom of speech issue. First question is, would you agree with that decision?
Since this is a content-based question, I actually would support the university's stance that people should be allowed to speak. People should not be allowed to act in those ways. And frankly, this current political environment is one that highlights, again, the need for us to be able to confront points of view that we disagree through speech. The remedy to bad speech is good speech, more of it, and countering the points made in the bad speech. It's a tough topic.
Thank you. Follow up to that. There was the most recent discussion right now has been about Section 188J3, the freedom of association. In your opinion, based on the research you've done, does this section break any new ground legally, or is it a reflection of what we have heard described as court cases such as the Rosenberger versus Virginia case?
There is a gray area in the legal precedents today, and I specifically refer to the all-comers policy. That currently, even though that's a precedent that's likely to be overturned at some point, right now it is still the law of the land that all commerce policies are legal. And the intent of that section, the 188J3, is really to make it clear that we do not allow all commerce policies because of the fact they basically destroy the right to free association. Again, think about any organization you belong to. Imagine it with a all-commerce policy. Would it still work? Any organization depends on picking who its members are and making sure those members share something in common that makes the organization beneficial to everybody and so on. Any organization, any club, anything, if you would apply an all-commerce policy to it and anybody could join, would be useless. It will just be used for, by the majority to stop any minority from expressing their points of view and from having a place where they can talk about topics that are not necessarily the majority point of view. So I would say that definitely that section is needed because right now the all-commerce policies are legally still on the table, and I appreciate again the commitment of the university that they're not being considered right now and they don't have them, but they would be allowed to bring them up in the future if the points of view of the administration changes, and I don't think that should be an option.
We got in this issue of freedom of association, and it's just rung some bells for myself when a little confusion here. If we have a Greek fraternity on campus, and it's an agricultural oriented fraternity, with the chapter requirements that to be a member of this fraternity, you have to be majoring in agriculture. If Mr. Cordelli beside me here wants as a student to come in and join that, he may be majoring in history, political science. Can that fraternity say, no, you can't associate with us?
The intent of that proposed legislation is to make sure that any student organization has the ability to choose who can join. Yes. And while I would personally say that if they are really interested in agriculture, the requirement that you actually have a degree on it is kind of silly, because there are plenty of farmers who never go past high school and they know more about agriculture than most people. The fact is that once you start taking away the ability of a student organization to choose who it is a member, most associations are just going to become whatever the majority wants, and we have to protect every point of view.
I don't think you're answering my question.
I apologize.
Yeah. In fact, it is a fraternity down UNH right now with this very issue, that it's built upon those which are majoring in that area, in that program, and their life, their environment, the way they work with each other is contingent upon that background and that learning that they're getting through UNH.
Yes.
Should we then allow that to be watered down? In other words, I'm just saying that if there's a requirement that an organization that does require, you're saying that, no, you can bypass that requirement and you can associate. And I don't think that.
No. I'm saying that the organization, any student organization, should be able to set their criteria and be allowed to exist and be allowed to set those requirements for entry. If anything, I'm opposing, I'm supporting the rights of any student organization to choose who can be a member regardless of what their criteria may be, because it's really what the freedom of association is all about, the right to associate with like-minded people that want to associate it with me. I want to associate with them. So this would be to protect that type of organization. If this legislation would be passed, the university would not have the ability to go to them and say, you have to change your rules for membership or else we'll take your chapter away.
Okay, thank you. Further questions, Representative Damon?
Thank you very much. Has the ACLU expressed an opinion on this bill?
I really appreciate the reminder. I knew that I missed something, regardless of how long my original speech was. Last year, as you do know, the ACLU did support the HB 516. Right now, I'm still in discussions with them because the ACLU representative who was responsible for this bill moved to a different chapter. And I just started talking to Gilles Bisonnet about the bill. And I think I would, right now, they did not have time to go through their process and evaluate it, but I did start the process. And I definitely expect that by the time the executive session is scheduled, I should have a clear answer from the ACLU. And if I was a betting man, I would bet on the ACLU supporting it, because it is essentially unchanged from a bill they supported last year. But at this point in time, they did not have time to reach a decision, so I don't want to claim either way. But I am talking to them, and I will definitely follow up to the committee as soon as progress is made there. Thank you.
Okay, I think we are done right here now. I'm getting eyes down here like challenging. Don't stop it, Hike.
Thank you.
I heard from you, Representative Cascadden. And so at that, with this, I don't have any more pink cards.
Thanks.
And so, Representative, if you could work with the university system, I see the changes you've made with the student organizations and the damages. If there's anything else you can come closer together, give it a shot.
Absolutely.
This bill doesn't have to be out of here till February 15th. It is an early bill.
Thank you.
So we have 23 of them in this committee. That's why we have to move quickly on them. So I'm going to close the hearing on 1305. And the hearing on the next bill here will be at 1 o'clock. We are going to take a break. Yes. Which ones are those?
We already got it? Or
Why don't you crisscross them and put them somewhere, we'll ask later. Yeah. Yeah, yeah. Okay, we're ready to go with part 2 of today's session, which is dealing with some bill from the morning. We're going to be starting with 1657, which is relative to prohibiting hazing at educational institutions. And we have Representative Greg Hill that's willingly offered to introduce the bill.
I don't think I'd go that far, Mr. Chairman, but
willingly?
Willingly is the operative word. So I will introduce House Bill 1657 FN and let you know that I have in my possession, and maybe in your possession now, it is, an amendment that I believe replaces all, or I've been led to believe replaces all of the original bill. And I have a prepared statement from the sponsor, who is in law school full-time this week and cannot miss any, but appreciate Representative Hill introducing 1657 for me. And this says taking questions, but it's wrong.
Are there any pearls of wisdom in there?
There are some pearls, actually.
Okay, let's go.
So this says, this bill updates the language that prohibits hazing at educational institutions. This bill is similar to bills passed in other states such as Washington, Virginia, Ohio, and New Jersey, and with many other states introducing legislation to move in similar directions. The amendment is a compromise with university system and administration members from UNH Keene and Plymouth, who met with me, meaning Representative Cam Kenny, met with me to discuss language that would make the bill workable in New Hampshire. I will briefly go over the amendment and point out the substantial changes that it brings to the bill. Page 1 until page 2, line 22, it offers straightforward definitions. The only significant difference between the bill and the amendments is line 21 through 22 on page 2 that defines student organization, which makes it clear the organization is formally recognized by an educational institution, as there are examples of unrecognized organizations that the institutions cannot act upon. Second one is page 2, line 33, begins the section that implements educational programs at the educational institutions. This section is different and more workable than the original bill based off recommendations from the university system and the institutions. In the amendment, the institutions are given the burden to provide an educational program regarding hazing. Initially, the student could be penalized for not participating by not being allowed to participate in recognized organizations until they complete the educational training. But this could have a counterproductive impact, such as incentivizing students to join unrecognized groups. Additionally, I realized that after the meeting, it would really not work in practice. But as page 3, line 4 to 6 shows, the institution would still verify what students participate. Therefore, this language still provides an educational program on hazing while ensuring that students participate without prompting unintended consequences. Page 3, line 17 offers language that has to do with institutions reporting hazing violations. After the amendment, each institution will offer an annual public report on known hazing violations. The amendment adds the requirement that the report will also state the number or percentage of students that participated in the educational program I previously mentioned from the last section. The last point worth mentioning is that this report will be included on the institution's website as shown on page 4, line 2 through 10. Page 4, line 27 amends RSA 631:7, which regards penalty for hazing. On the amendment, page 6, line 8, makes it clearer when compared to the original bill. Page 6 makes it clearer when compared to the original bill that the intent for penalization is for those who specifically engage in the act of hazing. This section specifies that aggravated hazing, which is hazing that results in serious bodily injury or death, page 6, line 9 through 10, is a Class B felony, page 6, line 21. All other hazing is a misdemeanor. The last relevant section, I believe, could use clarification comes at page 7, line 10 through 15. Misdemeanors have a 1-year statute of limitations. After talking with the university system institutions, it would be beneficial to have a statute of limitations at 4 years. So that is where the new section comes from when compared to the original bill. I believe the rest of the bill is self-explanatory. Sorry again for not being present to take questions, but Representative Hill is willing to take questions, as it is those who helped me help me draft the amendment from the university system. If any questions remain, please email or call me, and I will happy to discuss the bill / amendment. Sincerely, Rep. Cam Kenny, Durham.
Ready for questions?
Have a nice day, Mr. Chairman. I do have copies of the amendment, but I believe you all have them as well. I can certainly leave these with your, yep, I can do that. I think you're on your own.
Yeah. Well, we're gonna, Tom Cronin, would you like to come forward and explain the amendment?
I not have a copy of the amendment, though.
I can handle that.
All right, perfect.
Maybe. There you go.
Thanks.
You bet.
So good afternoon, members of the committee. Tom Cronin with the university system. Thank you for having us in on House Bill 1657. So as Representative Hill explained a moment ago, we did reach out to Representative Kenny when we first saw this in the system, just to have a conversation with him about what his intentions were and where he wanted to go, and then had a couple of very productive meetings with him on just how to make legislation like this a little bit more workable for the campuses. With the amendment, the university system is strongly in support of the bill. We think it strengthens the state's hazing laws, increases hazing prevention education in both post-secondary as well as secondary education, which we think is really important, and then allows us to develop sort of consistent reporting requirements across the state. I'm happy to answer questions. I do think Representative Hill really did hit some of our key points. I'll quickly reiterate them. Really one of the biggest concerns we have was the original draft would have prevented any student from participating in any university activities until they had completed the training. That is just impossible for us to enforce on an open college campus. We could not in any way prevent a student from going out and doing something. So instead, we really sort of took the approach that other legislation, think specifically the sexual harassment legislation from a few years ago takes, that puts the burden on the campuses to provide a program of education within, I think, the first 30 days. We also talked with Representative Kenny a little bit about the idea of, reporting on the participation in those, just to ensure that you all lawmakers are aware that we are offering it. And we're doing our best to ensure students are taking it. And I want to be clear too, a lot of what we're doing in this case are things we already do. We already include a module on training. We already, on particularly for fraternity and sorority websites, report instances where they've had disciplinary issues. So a lot of the stuff that's in this is just sort of being aggregated into things we're kind of doing already. Let me see, two others. The initial draft of the bill had us reporting semi-annually, twice a year. The amendment would change that to annual. Annual is also how we do our current crime reporting. Cleary, for folks who have heard that before. There's also federal legislation on this issue that, if it were to pass, would require annual reporting. So our thought there was just to align with those other items. And then the lengthening the statute of limitations was actually something that came from the university, not a lawyer. My understanding is a typical misdemeanor has a 1-year Class B misdemeanor has a 1-year statute of limitations. Hazing, unfortunately, is a crime that when it's committed, everybody's told to keep quiet. And we've unfortunately had instances, over a number of years where folks have come in and reported something either that they saw, maybe were involved with, but after that year, and then we've unfortunately lost the ability to, pursue that criminally. Certainly still take them through student conduct, et cetera. But by lengthening it to 4 years, kind of creates a little bit of more opportunity there to hold folks accountable if they're involved in this sort of activity. Those are, again, the three big ones. Representative Hill did mention recognized organizations. That was also a helpful edit. But would be happy to take questions, I think.
Thank you very much, Ms. Cronin. I have a question that's not necessarily policy, but it is finance. Did you, or working with others within the system or systems, address the issue that this bill could cost as much as $400,000?
So part of the FN, certainly in drafting the FN, was related to the couple pieces we need on ensuring the annual or the biannual reporting. So a little bit easier under the amendment. I think at one of our 3 institutions, we would need to develop the module that would need to be offered still. So there is a little bit of startup cost there. Mm-hmm. So yes, there certainly is a little bit of added cost to the mandate, for sure. But we think it's one that's worth undertaking.
And was the university system or community college system going to take that money from their surplus fund, or are they going to come from us and ask us?
I do not expect it will be included in our state appropriation request next year.
Yeah. Further
Maybe
questions?
some of the other bills.
Representative Myler.
Thank you, Mr. Chair, and thank you for being here. What is, my question is, thank you for taking my question. It's a simple one. What is the incident rate right now of hazing on your 3 college campuses?
Yeah, appreciate you asking. Very limited, thankfully. Certainly, you don't want to ever minimize the idea that there's such a thing as minor hazing. There are obviously instances of things that, particularly as written in this legislation, would probably rise to that definition. But in terms of sort of big incidences, I think at the university there has been one maybe in the last 3 or 4 years. I think Keene State, Plymouth State would probably say about the same. This issue of recognized, unrecognized organizations is in fact a concern. There are a couple of unrecognized fraternities and sororities at the university, a couple also at Keene and Plymouth, where it's a little bit harder to sort of police the activity of the group versus the students. The other thing I would also add too is, in working on this with Representative Kenny and our team, there is still an issue of, activity that could constitute hazing happening in clubs, in sports, in other areas too. It is not exclusively a Greek life issue, but again, to issues that rise to criminal complaints, very, very limited. I would say less than a half a dozen across the system over the last 3 or 4 years.
Follow up, please.
Yes.
A follow-up would be is how do you get the word out? You said that you're already addressing this within the institution. What's the process you use to make this, if this were to become law, how would you then get this word out to students?
The way we do it now and the way the bill speaks to it is as part of your orientation process. So all students are involved in orientation. So it is just part of the training modules that a student goes through during orientation. If you are involved in Greek life, it's regular training on that side. And then similar, again, mentioning the sexual harassment legislation, similar to if it becomes a more prevalent requirement, email, social media, et cetera, to ensure folks are aware that it's there and required.
Further questions, Representative Damon?
Thank you, Mr. Chair, and thank you for helping us understand this bill. Your remarks a moment ago about the low incidence of hazing, was that specific to the university system or to all educational institutions in New Hampshire?
I'm speaking for USNH.
If I may.
Yep.
I just want to clarify, the bill does apply to public and private institutions, and I think the incidence is different.
It may be.
Representative Belcher and then Representative Ford.
Thank you, Mr. Chair, and thank you for answering these questions for us. A lot of this stuff makes perfect sense. Some of it seems a little difficult to define. It seems pretty broad. So looking at lines, say 21 and then 22, substantial risk of emotional harm. Can you offer
what page?
Page 1? 121 and 22 lines. Substantial risk of emotional harm. how would that be defined in law? Would that include like just anxiety? I'm not sure exactly.
Sure, it's a good question. I'll say we raised that as a question. We didn't have a great fix for it in this first round. And I'll be clear too, we are happy to continue working on Representative Kenny's amendment to better clarify items like that.
And if I may, just one more on that same line of thought, line 27. Exclusion from social contact. Now that I can understand how under certain circumstances that would be interpreted rightly, but also we were just hearing before lunch about Supreme Court and the idea of being of student groups being able to exclude dependent on their own beliefs and alignment with that group. So wouldn't it be fundamentally true that a student might apply to a student group and not meet the qualifications and by definition be excluded from social contact in that group?
I think we're talking about two different issues in essentially the criminal definition of hazing versus potentially joining a student organization.
Thank you.
Representative Ford.
Thank you, Mr. Chair, and thank you for taking my question. I'm wondering a little bit in asking this question, whether or not this is almost too defined in some ways about the student group thing, or maybe not specifically. I am a former member of a college fraternity, and they did do very mild hazing. Others did more extensive hazing. But the athletes also did hazing who were not parts of fraternal groups. And so I don't see any reference here, and these were varsity athletes on each other, and sometimes they were very physical.
Yeah, no, so organization, so looking at the amendment, page 2, line 9, I think is pretty broad for exactly that reason. Varsity, club, athletics are included.
Okay, that just really concerned, that's my concern.
100%.
Are there further questions for Mr. Cronin? Yes, Representative Dry.
Thank you. So how much does this change what's already on your books right now about hazing?
Between what's on our books and how we're currently doing this, not a lot. Again, I think I forget if it was Keene or Plymouth, one of the organizations in the system would need to develop that training module in order to come into compliance. They are already doing training. I think this would, by doing it through the module, we'll be able to track the statistics, things like that. In terms of reporting, we already report to law enforcement, which is one of the requirements in here. In terms of reporting publicly, we, as I said, report at least on fraternities and sororities publicly on their pages. Training is already there. Again, the change on the statute of limitations gives us that ability to report to law enforcement longer, which we would appreciate. But in terms of day-to-day activity, it would be pretty similar.
A follow-up, just real quick. Can you talk about misdemeanor, again, statute of limitations? So it changes the time that you can act on it, but it doesn't, if you report after a year, would you be able to go after
So,
criminally?
correct. Again, good question I wish Cam, as a member of the Judiciary Committee, was here. My understanding is a Class B misdemeanor has a 1-year statute of limitations. So we have had instances where a student has come and reported an instance of hazing, alleged hazing, after that 1 year. And at that point, reporting to law enforcement, there's no value there. We still work through the student conduct process, assuming the student is still there, the accused student is still there. We would work through that regardless of the legal statute. However, by extending the legal statute of limitations to 4 years, it would give us a longer time to report to law enforcement. I do believe there's a requirement in the bill that we would have to report to local law enforcement within 72 hours of learning of an alleged incident, which is what we do already. It would just ensure that in the event that it has been kept quiet for whatever amount of time, there's still a legal avenue there as well.
Okay, thank you.
Are there further questions? Not seeing any. Thank you very much.
Thank you.
I'd like to call on this bill, we have Shannon Reed. Were you going to testify on this one? Okay.
Good afternoon. I'm Shannon Reed, representing the Community College System of New Hampshire. Excuse me. I've been trying to sort of toggle through the bill as introduced and the amended version, which I've really just been able to take a look at today. So my testimony is directed at the original version of the bill, but I'll try to kind of morph it into discussing the amendment to the extent I've been able to review it. So we certainly believe that this is a well-intentioned bill, but we would oppose it as introduced. And I'll outline a few reasons. And I will say at the outset that my testimony is going to be a bit parochial in that it's going to be specific to the community college experience of hazing. But I understand that this bill also applies to the public four-year colleges, private colleges, and the secondary level of education as well. So we already have well-established policies on hazing, including that any such incidents must be treated as violations of college policy and also in New Hampshire's criminal code. Reporting requirements already exist, including reporting to law enforcement and making reports publicly available and accessible on an ongoing basis. We publish a crime log, which we keep accessible to anyone who wants to see it. And this would be part of that. That said, we have had no reported instances of hazing in recent memory, going back for at least a decade, as I've been able to discern talking to my colleagues across the system. Certain requirements of this bill would necessitate hiring additional personnel. These include implementing and tracking the training program and preventing students from participating in campus activities or events until they complete the hazing training. And I understand that's been addressed in the amendment. I'd like a chance to take a look and make sure that it does in fact alleviate our compliance cost concerns on that score. Costs associated with this bill would have to be met by moving resources away from other areas of operational need. We have a number of questions I haven't been able to kind of review in enough detail, but the reporting piece of the bill and of the amendment could be certainly workable based on what we're currently doing. But the specificity in the bill might create some privacy concerns where we have small organizations. If there was an incident, it might be difficult to protect privacy interests while still meeting the reporting elements that are in the bill. So we'd need to take a look at that. I'm sorry, I'm trying to kind of go between the bill and the amendment. We had some questions that are similar to Representative Belcher's with respect to some of the language being potentially a little too vague and broad, like behavior which adversely affects the health and safety of the individual. That's a very broad phrase, and that could be in the eye of the beholder. And I could imagine an athletic training regimen that somebody felt they didn't want to do because it adversely affected their health and safety, which may or may not, be legitimately the case. So I would want to just potentially refine some of the language. So I would look forward to the opportunity to continue to work with the sponsors and my colleagues at the university system to just make sure that the concerns that we have that would create additional costs that were not, in the end, really helpful to the whole area of hazing prevention in a final version. I'm happy to take any questions.
Thank you. In my reading of this, I'm on page 2.
I'm sorry, of the amendment or the bill?
Of the amendment. Page 2, line 9, where it says Romans 8. It says organization means a club, association, corporation, order, society, corps, private, club, fraternity, sorority, varsity, or club athletic team, etc., etc. What about a JV team? What about a freshman team? It seems that this is only going to be applicable to your varsity team.
That's an interesting observation. It does seem to skip over from varsity to club.
Yeah.
I mean, I think we'd like a chance to take a really close read.
Yeah, and the second question I have, and then because just a cursory look too, or the thought, when we're talking about private 9 through 12 schools, private collegiate higher education schools, and there's a cost to doing this. Where is the money coming for those private institutions, or is this an unfunded mandate?
I think it probably would meet a definition of an unfunded mandate if this gets passed and there are costs that have to be met. I think that's the case for any type of institution.
Yeah. Are there further questions from the committee itself? Not seeing any. Thank you very much. Was there anybody else out there that wanted to speak on 1657? If not, we'll close it right now. And in looking at this bill, it's going to take, more work. And most likely some kind of a subcommittee if we see the need to move in that direction. So, just some thoughts. Now, the next one on the agenda is HB 1450. That's a bill that I have. I can introduce it right now. We should be able to get done this in about 5 minutes and then get back on schedule. So let's do that. So why don't you take over on that one?
Yep. Right, 1450.
1450, yeah.
Okay, we'll open the hearing on House Bill 1450, relative to establishing a commission on higher education consolidation. And I believe we have some materials being passed out. And it's all yours, Chairman Ladd.
Thank you. You're going to have materials coming around, and briefly, I'll just give you a little bit of explanation where we're coming from. The sheet you're going to receive has the first 3 pages show the governor's executive order for the task force, which is studying the strategic alignment of public higher education in New Hampshire. So I don't think there's any need. I think some of us have looked at that before, but there are certain tasks that this task force is looking at and already in the business of looking at the issue that the governor addresses. And the task force shall consist of, you can see on that who's a member of that commission. And there are certain requirements or tasks which the committee is asked to do. And those are on the second page of the governor's executive order. There's tasks shall be A and B, and C, solicit input from variety of stakeholders, which that group's already doing. The bill which I introduced was introduced at the same time this was put together. The governor's task force has to have all their work done and completed by the end of March. From my perspective, I think that's highly unlikely. There's just a lot to be done, and I'll go through a few of those things. So what we did was we put a bill in, I put a bill in that would be a placeholder in case there are recommendations. You can look at the title of it. It's not about merger, not about merger at all. It's looking at how we can align this whole structure to meet some of these responsibilities that the governor's order says we should be looking at. And my bill says the same, has same identical language in it. So the fourth sheet down is a timeline in which the task force has to meet. You can see we've already started meeting on January 5th and had in January 12th, which will be coming up this Friday. And you see in accordance that we should be somewhere close to getting done in March. It's kind of a hope, I pray. The next sheet down looks at some of the challenges which we're looking at, which deals with public school enrollment currently. And you can see from that chart, starting back in 2002-2003 school year, going down to 22-23 school year, what the trend line looks like in our state. We are losing students, K through 12. That has a direct relationship to what's happening in the collegiate level, not just in New Hampshire, but throughout New England. Fewer students, more competition to get these students. We're fighting other schools like UMass, University of Mass, Amherst and Lowell, Orono. We're competing for these students. And then the next sheet is a sheet which shows challenges of first-year student enrollment projections. You can see on that sheet, it looks like this right here. Yeah. You can see what the projections look like in year 28. Look at that trend line. It's going to get worse. That, in fact, will have a direct relationship with tuition monies coming in. That, in fact, will challenge the system to try and retain some of these students which are leaving our state to go to school elsewhere, to keep them in our state. That's why we have to work with the community college system, the university system together, the community college system with the 2+2 program, other programs which they haven't learned, including concurrent and dual enrollment, get students involved in it there. Hopefully they'll continue through with the higher ed 4-year program. There's many, many issues which that committee is tasked to do. The next sheet down is a sheet that comes from the community college system, supporting New Hampshire's communities and workforce. 93% of our students are New Hampshire residents. That's wonderful. In the community college system, you see where we're pulling from. We're pulling from adults in our community, a student that's a little older than it is for the four-year system. Campuses through New Hampshire serve communities and support local employers and industries, and are really tied tightly together with the small business and business in our state, trying to adapt and mold towards where we want a workforce to be now and in the future. And as it was stated earlier today, I think Ms. Reed talked about 21,000 to 22,000 students in the community college system. You're right on the money. And it's done through these skills certificate programs. But we got to predict this, we talked about even with the 4-year system of transitioning students from one to the other without loss of credit, without loss of time, without loss of money. These are all tasks which the system's going to have to look at. And all points to governance too. The last sheet there comes from the university system, and it shows you what the enrollment of 4-year college students, where they're going in our state. You can see the majority of our kids, 56.4%, leave the state. Then you can see that 27.7% go to the university system. And privates are 15.9%. This is from the university system in New Hampshire. You can see the enrollment changes, which obviously are shrinking. Several wonderful points to be looking at. So we have a system that's been very effective, both at the community college system level and the university system level. That's why I'm not really supportive of any kind of merger, but I am supportive that we got to look at how we're going to continue funding this, where we're going to get our students, how we're going to keep our margin in the profit range rather than having more expenses than we are revenues. And that's also reflected on the state sheet. How to reduce the student tuition costs. If we want to attract students to stay in the state, we're going to have to do something about reducing those costs. On the other side, you can see the average net price of attendance, New Hampshire undergrads. In comparison to those privates in our state, UNH, PSU, and Keene State are down lower. You can see the costs there in that right-hand column. Some of the initiatives that we have to look at in terms of this Higher Education Study Committee are listed there. And the risk areas of enrollment and facilities and infrastructure. When you have 7 community colleges and 3 now 4-year systems, we have a lot of facilities. We look at a lot of capital costs out there, and we're dealing with deferred maintenance. We're dealing with a lot of issues. We need to be looking at how to operate more efficiently and while providing an adequate, not adequate, but a superlative education for the students which are working into pathways here in our state. So the bill is set aside as a placeholder to support the task force that is currently looking at this. And currently, the last meeting we had, Representative Lunel, you're on that task force. We're looking at who are the stakeholders that we have to get information back from. Educators, yes. Students, yes. Administrators, yes. So many different people are involved in that whole process. So we have to do a lot of research and a lot of gathering of information. then move forward with some solid recommendations. And there are those on that task force who like to see some solid, progressive recommendations rather than just kicking the can down the road a little bit. And we've done a lot of that. And we've done some wonderful things. You know, the 1530, which was Representative Ford's bill here a few years back, where we looked at trying to coordinate the career pathways. We have established 30 pathways right now, of which 10 we have it universally done now throughout. But we have to get those other 20, and we're closing in on those as well. Those are just a few of the things which were going to help us create a more cost-efficient system. So I'll conclude, and I'm asking that we just keep this as a placeholder until we have to get rid of the bill, and that time we may know how to amend it with some language of some kind so that we can get it to the Senate, so they'll have it as a placeholder as well if we act, because we're going to have to rid that bill by March 15th. By March 15th, right? So we have some time there, but if in fact the report comes out from that group somewhere in March, by the end of March, it's tight. And so if we have some recommendations to have to go forward, that's one way that are going to need some legislative support, we can do it.
Any questions for Chairman Ladd? Representative Luno?
Yeah, thank you very much, Mr. Chair, and thank you very much, Rick, for putting this in, because I think this will provide a good vehicle for the.
Point of order.
Yes, your point?
Representative Luno referred to our speaker by his first name.
I'll Representative Ladd. No, that's fine.
You're welcome, Representative Luno.
No worries. So,
yeah.
But would you? And I'm not suggesting that we go ahead and start amending this now.
No.
But just as far as the title of the bill and the use of the word consolidation, and you know, maybe a more something as we do go forward with it, Commission on Public Higher Education Systems, because it really.
You are correct, and that title was put in by the folks across the street.
Okay.
And one of the things I had talked with them when I was discussing that, I said there are some things we're consolidating. For example, President Dean down at UNH decided with his staff they're going to move the athletic training program, the only athletic training program we have, to Plymouth State University due to their wellness center up there and their track, the indoor track. So that was a consolidation of programs. The program was put where it was going to be more effective, and we're consolidating down to one program in the state. There's areas where we can consolidate. We've done it with law school.
Absolutely.
And those are absolutely things which we got to look at. Consolidation is a bad word. That has not been a pleasant word for the community college system. They're here. They think, wow, we're going to try to eliminate that structure. No, I feel all these campuses serve a specific purpose, and it can be done. But there are a lot of efficiencies of scale and other areas that we can address to make it run so that we can run with the capital we have, and also be reaching out and educating students the way we should be doing and are doing.
Further questions, Representative Cascadden?
Thank you. Thank you, Mr. Chair. Thank you, Representative. My questions are really just to clarify my understanding is that the governor has issued this order for a task force, and the reason for the bill is to ensure the task force does its work. I'm not really clear on when you call it a placeholder. I don't understand what that means.
It's not to ensure that they do their work.
Okay.
It's to, if there are some recommendations that come out of the task force that can occur through legislation, this is the bill or the process to carry forward the recommendations that come out of that task force.
Understood. Okay.
Yeah.
Thank you.
Yeah.
Anything further?
And that's what's been communicated with the college presidents and in a long discussion with Mark Rubenstein over that. And so I think we're on that same page.
Seeing no further questions, thank you, Representative, and we'll close the hearing on HB 1450. And we'll move on momentarily to HB 1436.
Okay, I got one card on that, 1436, but I need the sponsor.
Yeah, he's sponsored. Co-sponsor is here, Belcher.
We need a presenter, Mr. Belcher. Let me introduce or state the bill first, please. We have HB 1436 is relative to requiring institutions of higher education to maintain certain statistical information on their websites. And so I welcome Representative Belcher to introduce the bill.
Good afternoon, Mr. Chair, members of the committee. So I did not write this bill, so some of the more technical aspects of it I may not be super useful, like the URL, XML stuff, but policy-wise, I should be able to do a fine job here. The idea of what this bill is meant to do is to create transparency and openness that is available to all persons, both prospective students, members of the public, and people like us as a legislature. Now, we want to be able to break out information. We want to be able to know what kind of debts students are incurring in various disciplines, what their job prospects are from various disciplines. We believe that's important both for us as a society, because most of these institutions are public, they're publicly funded, and also for the students who can do it. Now, there was some consternation about breaking certain demographics out of this information. Here's why it's so necessary to be able to do this. Recently, the Supreme Court issued a major ruling striking down the practice of Harvard in their admissions process using something that Harvard was referring to as diversity, equity, and inclusion as a part of their onboarding of students. Now, what the Supreme Court said is that by having different standards for different people based on immutable characteristics like race and gender is legal. They said that is a violation of civil rights law. Now, in order to actually know if colleges and universities are living up to this ruling, we have to be able to break out this information to be able to analyze it. For us as a legislature, for the public, for openness, and also for those who would be interested in attending these universities, because they have a right to know whether certain people, including themselves, might be subject to discrimination in the process of being admitted or going through these programs. And that's it in a nutshell. I'll happy to take questions.
Are there any questions for Representative Belcher? Yes, Representative Tanner.
Thank you, and thank you for taking my question. Who actually wrote the bill, or does this come from an organization?
No, this was Travis Corcoran, Representative Corcoran.
Thank you.
Representative Cordelli.
Thank you. I'm looking at lines 21, 20 and 21 on page 1 of the bill. Average standardized test scores. At the university level or community college level, what standardized tests are you looking at getting feedback on?
This would be standardized test scores for admissions that were utilized.
So, like an SAT score, ACT score, is that what you're indicating?
Yes, whatever the college is using as far as a standardized test, whatever they're accepting for the admissions process. And again, this goes back to the Supreme Court ruling where they found that Harvard, the institution of Harvard, was applying different metrics using the same tests by race and gender, which was found to be unconstitutional.
Go ahead.
Over on page 2, lines 4 and 5, you're looking for the employment rate within the field of study within 6 months of graduation from the program. So how do you envision the institution getting that information? If the person moves out of state, accepts a job in California, how are you going to collect this information, employment rate?
Thank you. That's a good question. I believe it was the belief of Rep. Corcoran that this would be done through a simple survey process of graduates.
Okay, thank you.
Are there other questions, Representative Ford?
How do we account for things that seem more anomalies than we think going in? The example I have in mind is we graduate a lot of people in education. And a lot of those people who graduate in education, as it turns out, are ideal candidates for management, sales in particular. And that people are hired for their people skills that they developed in a program for teachers, but they're hired to be salespeople in industry. And how do we then say, gee, they didn't go into teaching, but why? They went into something else. But how does that get reflected in the numbers? What's really happening with those graduates?
Thank you for the question, and it's a good question. Strictly speaking, this would not track data from somebody graduating from one program and going into a job in what would traditionally be considered an unrelated field. It would only track those going into a field that would be related to their degree program.
Thank you.
Other questions from the committee? Representative Cordelli?
Thank you. Toward the top of the first page, the institutions of higher learning have to maintain information on a web page on their website, the institution's website, I take it.
Yes.
On lines 10 and 11, for that information, you're expecting the commissioner of the Department of Education to specify the font size, et cetera, for the web page of the college?
No, I don't think there's any necessity to specify it. I think it's just saying that it has to be congruent to what is already being used as a part of the website. In other words, it just can't be tucked away somewhere in tiny font.
But that would be by the commissioner of the Department of Education.
I'm sorry, I'm not sure I understand the question.
The commissioner of the Department of Education would monitor the font size and so forth being used on the UNH webpage.
I suppose.
Any other questions? Representative Cornell and then Representative.
Thank you. And thank you for taking my question. There's no fiscal note on this, and I can't imagine that I imagine it would cost the university or the other systems a bit of money to do something like this.
Point is taken. I would imagine there would be a cost associated with developing a website. I don't know what that cost would be or why there wouldn't be a fiscal note.
Doing surveys and tracking, like for the University of New Hampshire, every year, I'm sure there's a large number of graduates, so trying to contact all of them will take somebody a lot of time.
Perhaps to do a mailing or something to that effect. Yeah, there certainly would be a cost associated. I don't know why there's no fiscal note. That certainly wasn't my doing.
Representative McDonald?
Thank you, Mr. Chair, and thank you for presenting this. I do like the merit of this bill, but as other committee members have pointed out, there might be some little details that need to be changed, and I can see a few other places myself. But how would you or the prime sponsor, considering what has been said, seek amending this language?
If I were the prime sponsor, frankly, I like the policy in it, and that's why I'm signed on to this bill. The more technical information in here is not my area of expertise, so I don't know if that would be useful to amend or not.
Thank you.
Representative Cordelli?
Thank you. One more that I don't understand in here. Page 2, lines 15 to 18. The university or college has to maintain at least 99% uptime, monitored, I guess, by somebody or reported by the college to somebody. But if they don't maintain 99% uptime, they lose their nonprofit status?
Yes. presumably I don't know the exact numbers that are sort of in common usage, because again, this is a technical item and I'm not a technical person when it comes to the web stuff. But the idea would be that this can't be a usually under construction kind of website that isn't available to the public.
Okay, are there any more questions, Representative Damon?
Are there other state university systems that are doing something like this?
I'm not sure.
There are organizations like the National Clearinghouse, which we get information from them in terms of 6-year degree, 4-year degree. And I'm sure that we have Mr. Cronin is also going to speak. He could convey some of that to us because they are a clearinghouse for this type of information, which could be available.
Excellent.
The National Clearinghouse. Yeah. We had a debate on that down in Senate Ed one day. I can't remember when that was, maybe 3 years ago, and where we paid dues to it. Yeah. Representative Myler.
Thank you for taking my question. This applies to all higher education institutions, public and private. Is that the intent of the bill?
It applies to all nonprofit institutions of education, higher education.
Okay, any further questions? And the private stuff is available. If you look at the sheet I just passed out earlier, you can see what the price of attendance, average prices for St. Anselm's, for Dartmouth, for Franklin Pierce, Colby Sawyer. That information is all available through the clearinghouse. And so there's some of this data is available, but I don't know to what degree.
Sure. And I think the big point was to try to make it more granular on a degree specific basis, what the job prospects are, how long it's going to take to pay back your loans, things like that.
Yeah. And we have research too that been on restructuring where we know that 2/3 of the land grant student populations in some of these colleges are attending 12 specific majors. All those other majors have the other third. And so obviously, which is more cost effective? Further questions? Thank you very much for introducing it. Tom Cronin.
Good afternoon, members of the committee. Tom Cronin, University System of New Hampshire. So USNH is opposed to the legislation as drafted. Certainly some of the questions during the opening testimony got to some of our concerns. At the end of the day, I'd suggest ultimately the bill would require every institution of higher ed in the state to develop lengthy dashboards of statistics that would be difficult or in some cases simply impossible for us to develop and manage. And it's also incredibly duplicative of efforts that are already ongoing at the federal level. So the second part first, the federal government has currently the Department of Education's College Scorecard. Simply just Google US DOE College Scorecard, and you can pull up every institution of higher ed in the country and scroll through really a number of the statistics that would be required by the legislation, including, but not necessarily limited to, enrollment, cost, completion rates, starting salaries, campus diversity, et cetera. And they do it in a very consistent, accessible format where you can compare any institution to any other across the board. In addition to what's already there, literally within the last couple of weeks, the federal government just finalized new called gainful employment rules. And those rules are going to require institutions to also share data that will allow calculations on debt to earnings and really the financial value premium of higher ed. And the way they're able to do this at the federal level that would be very challenging for us is the federal government is able to take the information we report through IPEDS, which stands for the Integrated Post-Secondary Education Data System, and cross-reference that with tax information federal financial aid information and other pieces of data that only the federal government have access to in order to then produce a picture that consumers, students, and families can look at when making their higher ed choices. We simply don't have access to all that information in a way that we could produce a lot of this data in an incredibly reliable way. For example, the representative mentioned employment rate. So we do across the university system what's called the first destination survey. So we ask all of our students within the first few months of their graduation how they're doing in order to get a sense from them how they're doing, right? And so we're proud to say, across USNH, that we are about above a 90% success rate is what it's called. So either more than 90% of our students are either working or pursuing further education within 6 months of graduation. We certainly use that in our materials when talking to students, but we also wouldn't call it it is a self-reported survey. It is not, completely reliable data that should be put against how anybody else does that survey. In addition to that, starting salaries, as I mentioned, would have to be self-reported, would be incomplete, unreliable, because we don't have access to their tax information. So really for us, those are the two main concerns. Is the federal government is already doing and is mandating that we do a lot of this work in conjunction with federal data systems, and the stuff that's sort of left is left for a reason, because it'd be very challenging to develop it in a reliable format. Happy to take questions.
Thank you very much. Are there any questions, Mr. Cronin? Yes, Representative Lickes.
Would there be any reason why you wouldn't be able to just take that data from the federal website and put it on your website so that a student or a parent who was just going through looking at your website as opposed to where is this information on a federal website, be able to just look at it?
Sure. Would there be any reason? No. I think we do. And I will say, if you were to poke through any of our websites, you will find a lot of information on enrollment. I think we're proud of most of the data that's up in the federal system, and we do use it when talking to prospective students and families, for sure.
Okay.
Yep.
Thank you.
But I don't think it's necessary that we duplicate that effort or mandate that we duplicate that effort.
Further questions? Thank you very much.
Thank you.
And Debbie Skive, is that S-C-I-V-E? Pardon me? I-R, okay.
Everyone. Thank you for the opportunity.
Excuse me, press the silver button on.
Let me try again. Thank you very much for the opportunity to speak to this committee regarding HB 1436 relative to requiring institutions of higher ed to maintain certain statistical information on their website. I'm Debbie Skiri, and I serve as the president of New Hampshire College and University Council, and we respectfully request that you oppose this legislation. The NHCUC, as many of you know, is a nonprofit consortium of public and private institutions of higher education in our state, and these institutions are recognized and highly regarded for their outstanding teaching, research, and community service activities. They serve as major centers of activity, and they are vital to the economic development of the community in our state. The New Hampshire College University member colleges and universities are deeply concerned about college costs, student debt, and the extent that our students are prepared to find their way in our state's economy. Our institutions are committed to working with students and parents to help them identify the best institutional fit for their college education. Transparency and openness around college pricing is critical, as well as is alerting students to programs that could potentially leave them in debt. We appreciate the sentiment behind 1436 to ensure students and parents have important information about college costs. However, we are concerned that HB 1436 is duplicative of nearly identical federal regulation by the U.S. Department of Education, scheduled to go into effect as early as July the 1st, 2024 of this year, and therefore creating additional costs.
This regulation is known as the Financial Value Transparency Framework. It's a mouthful. This regulation will cover all programs that participate in Title IV, which is also known as federal student aid, financial aid, and it will include the following statistics. So debt to earnings measures that reflect the affordability of loan payments for graduates, an earnings premium measure that evaluates whether program graduates are likely to be able to earn more than a typical high school graduate, the published length of each program, the total costs of tuition fees, books, supplies, and equipment, students' likely earnings after graduation, and also the median student loan debt. The published timeline indicates that institutions of higher ed will be required to start reporting July 31st, again of this year, and these data points will be released as early as 2025. The goal of this, the Financial Value Transparency Framework, is to empower students and their families to make informed, apples-to-apples decisions among all colleges and universities across our nation. So the idea is that there would be one spot where people could sort of like look right straight across and compare program by program on all of these different metrics. Passing 1436 would further increase college costs as institutions would need to hire staff to monitor their website, given what's already been pointed out, the really harsh penalties proposed in this bill, including loss of nonprofit status and the right to bring private action against the colleges and universities. Again, thank you so much for this opportunity to talk about transparency and costs, and I'm happy to try to answer any questions. And also at the bottom, you'll notice the source, which is also coming from the Federal Register, which really outlines in a lot more detail what they have planned on the horizon.
Thank you very much.
Thank you.
Yes, Representative Lekis.
I just want to make sure I understand that the federal program is going to be based on the actual course of study, major, whatever, so that they can compare one course of study to another course of study to make a good decision that way. Is that correct?
That is correct, I believe. It is going to be organized on what they call a CIP code, CIP, which groups programs that are very similar together.
Okay, thank you.
You're very welcome.
Yes, Representative Ford.
Thank you, Mr. Chair. Thank you for taking my question. Would this sort of a provision also include inducements by colleges and universities to buy lower tuition, for example, to participate in certain programs, so that if you were going to enroll in this program, you would get a lower tuition, or in another program, you'd have to pay the regular tuition, something to that effect?
I think, it's still in its infancy. I think the goal was really to get at that openness and transparency, to put the information out there, and that it really would be, the goal would really just be to serve families and students regarding exact costs as they stand.
Thank you.
Further questions? When you're publishing information relating to, let's say, tuition costs at a school, and we know that the tuition costs you read, for example, like for UNH, may be here, but the actual cost may be down here as a result of grant programming which is offered to students. Which one is published so that we can get an actual, for if you're in this income bracket, your tuition may be significantly reduced?
I would imagine because it is based on a website that they would have to be created in a way that would sort of fit the most number of people in order to have it be useful. So if you're talking about an individual student, I think that would be in their circumstances, their income, and all the things that you're alluding to, I think it would be kind of hard to be able to print that out on a website. So I would guess it would be probably the average tuition. I really don't know. It may be printed within the context of the document. We could check that out and see.
Kathy Provencher, do you have any comments on this particular topic? As you've been the treasurer of the state, and now you're chancellor. Oh, well, you're acting.
My name is Kathy Provencher. I serve as the Chief Administrative Officer of the University. Two quick comments. there's no fiscal note because the university system and community college system were not provided the bill to write a fiscal note. And number two, the college scorecard does provide net average tuition. So it would be net of financial aid, but it's a big average. And that information is generated from iPads. Mr. Cronin referred to earlier, I'm not going to remember all the words in the acronym, but it's a database of information that is gathered from colleges across the country by the federal government in tuition, financial aid, room, board, books, fees, all of that. And so it boils it down after financial aid to an average cost of attendance for schools across the country.
Thank you very much. Are there any further questions for? Thank you. Are there any others that would like to speak on this bill? Not seeing it, we'll close the bill. The hearing. 1436, done. The next bill which we have is HB 1690, relative to hiring, promotion, graduation, or admission in higher education. Do we have a sponsor here? Oh yeah, we got ahead of ourselves? Wow. And you're going to be headed out. You're going to go.
Good time to
Okay,
switch.
Yeah. Okay, Margaret. Yeah.
Quick switch.
Thank you very much. You stayed with it. You stayed with it. Yeah, yeah.
Thank you, Mr. Chair, members of the committee, Mike Belcher. That was strange. Again, I'm not an author of this, however, I do have some understanding of the policy position that it's looking to take, though the technical details I might not be particularly well versed in. So this is at its core an anti-discrimination bill. And much like the last bill I introduced, it jumps significantly off of this recent Supreme Court ruling that came down against Harvard University's admission position. Now, we saw in the aftermath of that Supreme Court ruling, which prohibited using different metrics based on different immutable characteristics to give preferential treatment to any group of persons, that though colleges began moving away from the explicit and obvious discrimination that was being used, as the Supreme Court highlighted, we saw some colleges come out and openly say that what they would essentially do is, since they could no longer utilize test scores and break out things like that as a way to discriminate, what they would do is they would simply solicit information in other means. And some of those other means include either self-reported or the solicitation of what is so-called diversity, equity, and inclusion statements, which are, in this context, seeking to ascertain specific information about the applicant in terms of gender or race, whereby subjective measures can be applied to a statement rather than objective measures such as test scores. And what that amounts to is a way of conducting the same sort of discrimination, which was ideologically motivated, that was struck down by the Supreme Court, and burying it in a way that makes it harder to locate. And in that same vein, the requirement of these sorts of statements, which are essentially ideological statements of faith, are something that should be prohibited in general. So I'd be happy to answer any questions on that line. Again, the technical aspects I probably can't help with on this bill, but.
Okay, are there any easy questions for Representative Belcher? Okay, thank you very much.
Thank you.
Like to ask that you both can come up together if you want to. Nadine Petty and Dottie Morris. Nadine, you're from UNH, and Dottie, you're from Keene State. Welcome.
All right, is it on?
Yeah, you're good.
All right, thank you, everyone. So again, my name is Nadine Petty. I'm the Chief Diversity Officer from the University of New Hampshire. And I'm here this afternoon to offer testimony in opposition to HB 1690. There are three main reasons for this opposition, and I would respectfully request that this group also hold opposition to that. First, HB 1690 is redundant, which makes it fully unnecessary. The USNH already adheres to both state and federal anti-discrimination laws and has been in compliance with these laws since 2012 in all aspects of hiring, promotion, graduation, and admission practices. As it specifically relates to hiring and the use of diversity statements within application materials, at UNH specifically, there are checks and balances in place during various stages of hiring to ensure that candidates meet stated qualifications of job descriptions. Something to note is that information about the race, ethnicity, gender, disability status, and other protected identities of individual applicants is withheld during search committee deliberation processes to ensure a fair and unbiased, or as fair and as unbiased a search outcome as possible. And I do want to correct something that was stated during the introduction of the bill. Diversity statements do not ask any applicant for their race, for their gender, for any kind of protected class information. Applicants in the hiring process are not required to include information about their protected identities in diversity statements. The statements instead are used to assess the ways that applicants are prepared to engage in respectful and productive interactions with students and with colleagues, regardless of identities. Second, HB 1690 is unclear and it leaves room for interpretation and misunderstanding as it relates to what a diversity statement is and how such statements are utilized within USNH. It is also unclear if the proposed prohibition is addressing both written statements and/or verbal statements, and to what extent. Questions about diversity and inclusion and USNH's commitment to these values or statements about personal commitments to DEI are sometimes initiated by applicants without solicitation. So it is also unclear if the bill is proposing law to censor inquiries or statements an applicant might make of their own volition. Thirdly, the proposal for private citizens to bring legal action against any New Hampshire institution who might utilize diversity statements is troubling given the vagueness of the bill itself. There is a lack of understanding of how diversity statements are used, and the bill's lack of clarity will inevitably subject USNH to expensive and regular frivolous litigation that could affect educational access for thousands of students attending public institutions across the state. I'd like to turn it over to Dottie.
Good afternoon. As mentioned before, my name is Dottie Morris, and I'm the Associate Vice President for Institutional Equity and Diversity at Keene State. I've had the honor to serve so many young adults since 2008 in this position. So I've had conversations with hundreds, if not thousands, of young people in the state of New Hampshire about this issue. I too would like to support my colleague in opposing this particular bill. And the main reason is academic excellence. These types of statements allow for us to draw in more people, to have broader perspectives. So the statements that we would ask of an applicant is around perspective, around how would they provide an education that touches the majority of students, if not all students. So it's making them think in an intentional way about how do you best provide a service for students. In all of my years of working with students, as I say, I've been in this position since 2008, but I've been in higher ed much longer than that. I started when I was 12. But this whole idea of looking at and hearing stories around young people talking about what was so helpful to challenge their own perspective, the way that they thought about things. And this is what these diversity statements, to get an idea of how people are thinking about this, who will be mentors and will be supporters of young people as they develop into the citizens that we need, not only in the state of New Hampshire, but in the United States. And I think by creating more and more roadblocks to people being able to have those discussions, it doesn't allow for us to give the best possible opportunity to the young people in this state to be very competitive outside of this state, and also to help this state grow and mature as we know it can do. So part of the reason that these statements are important, part of the reason we have statements of commitment for diversity is because it's not just for a small group of people, it's for all students. And if we could interview students and find out, they will definitely tell you that they were challenged. And in that challenge, they were able to create more innovative solutions than they would have with just having a singular way of thinking about something. And we all know that there are some complex issues we're dealing with, and it'll take multiple perspectives in order to be able to successfully navigate the troubles that we have. So for that reason, I would ask for you to oppose a statement that has not been used to narrow the pool of people. As a matter of fact, it's used to broaden. It's used to create an opportunity to have a rich conversation within classrooms and to allow for people on campus to feel like they belong and they can be active and engaged citizens of the United States of America. So I really do, because of academic excellence and all the other things that we hope to have a strong community and connection between individuals from diverse backgrounds, that you oppose this. Thank you.
Are there any questions from the committee? Representative Cordelli?
Thank you both for being here. I heard a little bit about what was not on the diversity statements, and a little bit about what you hope to accomplish with the diversity statement. Could you tell us a little bit about what is on the diversity statement? And I think it's quite important, as this bill is calling for elimination of funding for you if you have diversity statements.
Yeah, so I'll go ahead and answer that one. So there is not a specific statement in a diversity statement. So the search committees have the right, because we use them for not even for all searches, for some searches, for some positions, we use them specifically to talk to what is going to be expected for the actual role that we're hiring for. So some examples of some diversity prompts that have been used in the past, for example, might be a question that says, tell us about how you have incorporated inclusivity in your field research. Okay, and that's one example. Or tell us how you have considered disability in your teaching pedagogy. That's another example. Those are examples of diversity statements that have been used at the University of New Hampshire.
Thank you. Representative Myler?
Thank you for being here and thank you for taking my question. What has the impact of the Supreme Court decision had on your work? And how has it differed as a result of that decision? Thank you.
Are you referring to the affirmative action?
Yes.
Yeah, so it hasn't impacted us at all because we've been following that rule for quite some time. So nothing changed. I mean, essentially what we did is we went back just to make sure that we were continuing to follow those policies. We just sort of did a double check on our practices and on our policies, just to shore up anything that might have been a loose end. But like I said, we've been following anti-discrimination laws for quite some time. And so there was no impact to us. Yeah.
Further questions from the committee? I got one regarding Keene.
Yeah.
You have the Cohen Center over there, which is an excellent center dealing with the Holocaust.
Yes.
And your program deals with diversity and acceptance of differing positions and thinking. How is that occurring over Keene right now? Are people all accepting people that may be Jewish or maybe Muslim or maybe Presbyterian and without this other stuff that's going on in our country?
Yeah, as with all human behavior, it's complicated. And so what we are providing are opportunities for people to have those conversations, and not just a surface level conversation, but the type of conversation that attends to the nuances and the complexities involved in all of this. And so in our efforts to do that, we make it very clear around expectations of interacting with one another. We don't silence anyone in that idea of having those conversations. And it is being led by the Cohen Center and a couple other organizations on campus. We've had several conversations, and I felt like they were very productive conversations on campus over the past few months.
Thank you. Further questions from the committee? Thank you very much for coming today.
Thank you.
Shannon Reed. These were his introduced.
Good afternoon. I'm Shannon Reed, representing the Community College System of New Hampshire. We respectfully oppose this bill, and I would echo some of what you've heard before. The community college system is subject to existing state and federal anti-discrimination laws, and we take adherence to these principles and these laws very seriously. However, there's significant uncertainty in some of the language of House Bill 1690, and the severe penalties for noncompliance are of great concern. I go to specifics, and I'll give a few examples in the bill. So, for example, in the hiring environment, a candidate for a position might wish to highlight something in their background that demonstrates experience supporting diversity and equity initiatives. Would receiving such a statement place the institution at risk for noncompliance with this bill, since the word that's used is permitting? an institution can't permit diversity, equity, and inclusion statements. What exactly does that mean in the hiring environment? It's also unclear how broadly this language would be construed beyond hiring. For example, within institutional strategic plans that address a commitment to equity, to diversity, and/or to inclusion with respect to the populations that we strive to serve. Further language on page 1, line 26, talks about nothing in this section shall be interpreted as prohibiting bona fide qualifications based on sex, which are reasonably necessary to the normal operation of public employment, et cetera. We're not sure what that language is intended to allow, and we'd appreciate if the sponsor might be able to provide some clarification of that. The language that authorizes any citizen to bring suit against a college is either ambiguous or very broad and could be interpreted to allow a wide spectrum of people to bring a lawsuit. Potential awards could include court costs and attorney's fees, which could create an incentive for nuisance suits that could become draining of both institutional time and legal resources. Let's see, for the lawyers in the room, the evidentiary standard in the bill is atypical for civil actions and puts the college at a legal disadvantage. Once a plaintiff makes a prima facie case against the college, the burden shifts to the college to prove it has not violated a statute, and the college must do so via an evidentiary standard of clear and convincing evidence. Civil cases usually have a preponderance of the evidence standard. So the standard in this chapter is more difficult to meet than in a typical civil case. Also, the college is being asked to prove a negative that it did not violate the statute. We also have major concerns with the language that sets out the institution's liability and financial exposure. While we would attempt in good faith to comply with the state law duly enacted, if the institution is found to be in violation of this chapter and the full penalties contained therein enforced, we would be required to forfeit the entire amount of state funding we would otherwise receive in a given year, rendering the organization unable to operate and unable to meet its commitment to students. I would point out also that the community colleges are open access institutions, meaning we don't make the kinds of admissions decisions that might, where certain demographic information might come into play, as is the case potentially with other institutions. And when we talk about diversity, equity, and inclusion, at CCS&H, we talk about being places where anyone can thrive. As a student, as an employer, as an employee, our chancellor likes to say that New Hampshire, given its labor force challenges and wanting to retain a high quality of life in this state and high levels of civic engagement, we cannot afford to leave talent on the bench, which means we need to create opportunities for all New Hampshire residents, which means paying attention to what we can do to be those places where anyone can thrive. So I'll stop there because I don't want to be too repetitive of what's been said. I'm happy to take any questions, but we would ask you to consider ITLing this bill. Thank you.
Any questions of the community college system? So what would happen to the community college system if you made a mistake here and you would lose all your revenue from the state?
That's my reading of the bill. And at this point, we're about 50% funded by state appropriation.
Yeah. Big dollars. Okay, any further questions from the committee? Thank you very much. Are there any other folks who want to talk on this particular bill in the audience? Not seeing any, we will close this hearing on 1690 and enter the last one for the day.
It's 3 o'clock to start, so.
Pardon me?
It's 3 o'clock to start, so.
Plus for, oh yeah.
Is our sponsor here? Could we just, I don't know if there's anyone here to testify.
Can't we declare ourselves in a different time zone?
Yeah.
It's 5 o'clock somewhere,
Do we have,
It's 5 o'clock somewhere, yes.
do we have cards for this bill?
No, no, which one is, this is
1534.
1534, right. Okay, whose bill is this? Obviously, these people are not looking at the calendar.
And are we still getting emails for the notice of the bill that we're co-sponsor of?
Yeah, we should be. This went out. Well, we'll get it done quickly. Just open it up and close it. It used to be if a person didn't show up, For today. It's HB 1534, relative to establishing a program to earn tuition credits for state of New Hampshire higher education institutions through community service. And I'd like to welcome the sponsor of the bill, Representative Schultz, and with Representative Schultz is Morgan Casey. Welcome.
Thank you, Mr. Chair. It's the first time I've appeared before your committee, so it's an honor to finally be here with so many great educators and former school officials, et cetera. That is really cool. I am a rep for Concord in three wards, including Ward 4, where we're sitting right now. And it is my honor to serve. And I'm excited to be the sponsor of this bill because of a constituent of mine, Morgan Casey, who is a student at Bishop Brady. And this is really, she wrote the bill. And I'm here to be of service to this bill. And I think actually she's got a better speech than I could have written. So if it's okay with you, Mr. Chair, I would like to defer to her.
That's fine.
Thank you, Rep Schultz and Mr. Chair. My name is Morgan Casey, and like Rep Schultz mentioned, I am a senior at Bishop Brady High School. This is my first time testifying for a piece of legislation, and it is a pleasure to be here to introduce to you my triple win policy. This idea developed out of a homework project and some encouragement from students I met at the U.S. Senate Youth Program in March. I'm grateful to Representative Leno and Representative Schultz for their energy and encouragement. They have been great mentors. The national media has brought significant attention to the prevailing student loan crisis, which has generated divergent viewpoints regarding potential remedies. As of 2023, an overwhelmingly 93% of students bear some form of student loan debt, collectively amounting to $1.6 trillion. This predicament pervades every corner of our nation, including our own state of New Hampshire. President Biden employed an executive order providing $10,000 to $20,000 in an attempt to alleviate this issue, but it was ruled unconstitutional. Democrats and Republicans also differ in their views on this issue. To find a middle ground and offer a solution that appeases both political parties, I wanted to introduce specific legislation pertaining to the state of New Hampshire. This proposal aims to institute a unique option for tuition credit to alleviate future student loan debt within our state. This bill proposes that the state of New Hampshire credits $2,500 a year if a student volunteers 100 hours in one calendar year at state-approved sites, such as nursing homes, food banks, or homeless shelters. This opportunity would be available to all high school and college students attending a public institution in New Hampshire who are from New Hampshire. This offer would be renewable for up to 8 years, totaling a possibility of $20,000 in tuition credit. I think that this bill would benefit the students, the community, and the state. I appreciate your time in listening to this proposal, and I'm hopeful that New Hampshire could serve as a pilot for this program and help be a leader on the student debt crisis. Thank you.
Mr. Chair, I would like to add, I should have also mentioned, I also attended Catholic school where I grew up, and service is a huge component of a Catholic education, which I'm proud to have had. And to be able to think of this as sort of, instead of taking out student loans, if you need to, this would give students who've already been contributing to the community to pay for college in a way that would be, I think, fairer and representative of the service that a lot of young people, such as Ms. Casey, want to do for the state of New Hampshire. So it really is of great benefit, and I'm honored to be the sponsor.
Can I just make one more?
And if we have any questions, we're willing to take them.
Okay, thank you. Are there any questions from the committee? Representative Cascadden.
Thank you, Mr. Chair, and thank you to both of you for presenting this. My question is, you have in line 16 that it would be an approved volunteer site. Who is doing the approving and who's going to validate the number of hours?
So I
can take that if you want.
Okay, sure.
We would be open to your feedback on this, but essentially the creation of the program would lay out the administration of it. So the administrators of the program. So this would be, if you want, you already were talking about approved sites.
So I was also thinking that this could be part of a Department of Education role in a similar way that for mandated community service, those have been approved activities or organizations. We could follow a similar sort of system in which the Department of Ed would create state approved volunteer sites and then follow a kind of record system like the prison or mandatory community service uses. So that's kind of managed at a state level. And then if organizations not initially approved by the Department of Ed, maybe in the future they could apply to be a state approved volunteer site if they were if they were an organization in need.
Follow up.
Follow up, sure.
Is there any reason why it wouldn't go through your local school district as the approving?
We're open to that idea.
It just makes it local control.
Sure.
Thank you.
Representative Petronell and then Representative Damon.
Thank you, Mr. Chair, and thank you very much for coming in, proposing this legislation, and for taking my question. Can you tell me how much a high school student would make if they were employed?
Sure. So I actually worked at a sandwich shop downtown in the past summer, and I was making about $15 or $16 an hour. My friends who are currently employed make between $12 and I would say $16 an hour working. And so some of the ways that we came up with the $2,500 for 100 hours of service is that we want to make the offer appealing. If students are able to work and make more and earn more money to possibly pay for tuition than this program was offer, it would kind of lose that appeal. So we wanted to make sure that the students' time was being valued and that they were being compensated fairly for that volunteer time they were putting into these organizations.
Thank you very much. Excellent answer.
Representative Damon.
Thank you, Mr. Chair. Thank you for taking my question and proposing this really, I think, impressive approach. I'm wondering if you would be comfortable with an amendment that specifies that the organization that the student is volunteering in is a 501c3 nonprofit.
I'm sure we would be, but I wouldn't want to exempt potential service to government entities where appropriate. So as
maybe
long
both,
as, because that's technically not a nonprofit, I think that was our goal, was to look at where are their needs and government type assistance. When I did my junior service in high school, I said, can I volunteer for my congressman? So things like that should also be available if someone wanted to read to or work on literacy at the prison, if allowed. Programs like that shouldn't be off the table. Do you want to clarify?
I'm not personally familiar with what that organization or what that title is. Would you mind clarifying for me, please?
It's a federal filing that many nonprofits do that basically
Okay.
credentials that they are a nonprofit organization. Is that an adequate definition? Anybody else want to step in? Yeah.
It's a taxation issue.
Yeah.
Okay.
It gives credence to being a nonprofit.
Okay.
Further questions from the committee? Representative Belcher.
Thank you, Mr. Chair. Thank you for bringing this bill and for answering these questions. My question is, so if we're volunteering and we're being compensated at a rate of up to $25 an hour for that volunteer work, and that is taxpayer money that's being utilized, that is in essence being earned through this labor that's being done. I'm curious on line 21, why it would specifically restrict it from being used in private colleges. It would only be available for public institutions.
Well, I think that is an interesting point that we could consider. you made the point about taxpayer dollars. I will say there are already student loan forgiveness programs available to high-paying workers in various biotech jobs, and those don't have any parameters at all. As far, I could be wrong, correct me if I'm wrong, someone here probably does know that, but I'm pretty sure they don't have any parameters for income or for, any other sort of issue around that. As long as they're here in New Hampshire jobs, though that forgiveness is paid for by the taxpayer as well. So I will defer the other part of the question about why not private colleges to Ms. Casey.
We initially said public schools, public school students and public universities, just because I was thinking that we want, for example, I'm going to a private Catholic school right now, and service is something that's a mandatory part of it's one of the pillars of the school, service and education. And so we wanted to really make that opportunity available to public school students. And typically, the public universities have lower tuition costs than some of these private institutions. And so making that more affordable, for example, I think the average UNH in-state tuition is about $30,000. And this proposal could significantly cut into that, where some of the private institutions with $60,000+ tuition, it might not make as much of an impact. But we're not opposed to including private universities also.
Yes, Representative Woodcock.
Thank you, Mr. Chair. Ms. Casey, thank you so much for bringing this. I appreciate that and your work. My question follows up a little bit on Representative Belcher's. So am I understanding this right? There actually wouldn't be a cash transaction if the way you have it apparently structured, the state institution would see, say, a credit or a reduction in your tuition bill that you get, and there'd just be a credit. So the state school wouldn't get $2,500, period, right? There'd be a reduction. That's where it come from, because the school would reduce that. Is that your intent?
That's correct. This proposal, the credit, so to speak, would have no cash value. It would lower that tuition bill.
Okay. May I follow up one more? Sure. Thank you. If I started in school A, say UNH, or the community college I started at UNH and I do my first year, and I decide to drop out or transfer to Keene State. Can I get back in the program in your understanding, or is it just like it was one school? I'm thinking about how they're going to follow this around. Or you're not sure yet?
I think it would make sense to allow it to be available to any of our fine public institutions in New Hampshire. So I can't think of a reason why I wouldn't continue. We could think of this and could name it a scholarship program. Maybe that is more in the concept that we're trying to reach with this bill. And it didn't occur to me till this moment, the college scholarship, that probably actually is more accurate. A public service scholarship to go to our public institutions, I think makes sense, but to also as a way to keep students here. But to get to your question, absolutely, it should be portable.
Okay, that was my question. Thank you, Mr. Chair.
You're welcome. Further question, Representative Luno.
Thank you very much, Mr. Chair, and thank you very much, Ms. Casey and Representative Schultz for bringing this in this afternoon. I was wondering if you're aware that if a high school student began volunteering under this program at 100 hours a year, beginning their freshman year, doing it again sophomore year, junior year, and senior year, that they would amass enough tuition credit to essentially have tuition and fees fully paid for enrollment at a 2-year community college and earn a valuable 2-year degree following that.
Sure.
Yes, I think so.
So, and a follow-up, Mr. Chair?
Yes.
And given really the workforce issues that we're facing here in New Hampshire, I know that's compounded by a lot of other issues too, like housing and transportation and things like that. But do you see that as a positive? Because it's not an insignificant investment by the state. $25 million a year is what's estimated in the fiscal note. But given that we're already spending close to $45 million a year on community college, that this would be a good investment for the state.
Absolutely.
Thank you, Rep. Leno, for your question. And yes, I think I definitely see that as a positive benefit. One of the things with this proposal is to not only help students kind of reduce that barrier to entry and be able to get that college education, but also when they're doing this volunteer service and are in these communities, maybe forming relationships to, like you said, possibly create career connections. And when we're making college more accessible and affordable for New Hampshire students, they're likely to stay in state for that school. And it's helping our state gain those young professionals that can contribute to the workforce, that can help hopefully prevent some of that workforce shortage and ultimately generate economic output for our state.
Are there any further questions? So, for example, in my district, Woodsville High School requires community service for graduation. And they get the credit for that. Would the students then are doing it within the school environment? They go out and clean part of the Appalachian Trail. They do all kinds of things with community service because that's where we live, up in the mountains. Would they receive the credit plus this $2,500 you're talking about if they're taking it through their course at school, which is community service?
So can I just clarify, when you're speaking about credit, are they receiving academic credit for those service hours?
They're meeting all the academic credits required by the department. See, to graduate in the state, you have to have 20 credits. Some schools, maybe, I don't know where Bishop Brady is, they're probably more than that, 26 credits or so. Some are asking for more, which are electives, and this is an elective, but it's sort of like a required elective. You don't graduate unless you do community service. So if that were to occur, would that be eligible? Would that individual student, all of them, all the kids that are graduating, because it's a small school, only 240 kids in the high school, very small. It's another door you're opening up.
I'm open to the committee's feedback on this, but I think that would be reasonable and be allowed in this proposal.
Now, I have one other question for you, and this is getting down into the finances. We have a program called the Education Tax Credit, and that's done working with business. In other words, they put this money in a kitty, and so much of it goes to state, so much goes to the individual that's going to for education purposes, for tuition. Where is the revenue coming for this $25 million? It's tax credit, yes, but where's the revenue come from?
Sure.
I would say it would probably be the same source of where student loan forgiveness is given to those industries that receive the student loan forgiveness credit here. That is a state program, and I assume that's the general funds, but I'm not sure of the answer of that. Looks like Rep. Leno knows the
There are
answer.
different sources, like UNH offers grants as well, but that's something they do internally within UNH. So the tuition you see is not necessarily the tuition that the student's paying. It's usually a lot less.
We get that this is a very important question on any bill.
Yes.
We are flexible and would expect that this would also be considered an economic development possibility, even though they're nonprofits, because of the needs, the urgent needs, even at our county nursing homes, et cetera. This would be an added value because of that. So I think that investment pays for itself in a way. I also get that that is easy to say, and we're flexible in how to come to that
And I do have one last follow-up on all this. We have a number of students in this state that go to New London to school for college, Colby Sawyer. And that's because they want to get into the nursing program at Dartmouth Hitchcock. But it's a private school. And costly, more so than UNH. So we talked a little bit about the private colleges being eligible. If they go to a private college in New Hampshire, our goal is to keep these kids in New Hampshire and employed in New Hampshire after they graduate from college. This would be another way of accomplishing that end. If we involve the private schools, colleges that are in our state. But then then funding it is going to be a little bit different than what you've initially talked about here, because they're not state schools. Representative Luno, figure it out.
Right. No, thank you very much, Mr. Chair. And could it possibly also be done through partnerships with private institutions like Colby Sawyer in New London, where they recognize the value of students committed to the state, doing community service, and potentially a school like Colby Sawyer could also issue tuition credits the same way our state universities or community colleges could do. Would that be a possibility?
I think, yes, that could be a possibility in this proposal.
Great. Thank you.
Yes, Representative Damon.
I'm wondering if there was any consideration of evaluating a student's financial need, or would simply all public high school students qualify?
I mean, whatever you want to, however you want to say.
We are flexible on this. Initially, it was not need-based. It was kind of dependent on the amount of hours of service performed. It was available to all students, kind of regardless of that financial situation. But we are flexible on that option.
Again, I think that goes to the point that current student loan forgiveness programs that are state-based, I don't believe have any sort of income contingency. I do see a benefit to that, but we're talking really about the value of service. And that can come from someone with a wealthy background or someone not with a wealthy background. That value stands on its own, probably, but we're flexible.
Well, I definitely appreciate the value of service and applaud that premise, and I'm also trying to make the fiscal note look more appealing.
Nice.
Maybe I'll just do it from a policy perspective and then have Ways and Means figure this one out. Financially. Any further discussion from the committee on this bill? Do we have any other folks that wanted to testify on this? Representative Ford?
Thank you. If you move from service by definition to experience-based education, then you have a better position for asking for AP credit or something like that, which automatically guarantees the transferability because it's incorporated in a course. And so you created a course of experience.
That's a good point.
And that's the nature of it, and that moves it along as a course. So when you transfer to another college, the question is, do they accept credit for experience-based education? And that's increasingly common these days.
Can address that too.
Thank you for that suggestion. I think maybe incorporating that as a credit would help it be more flexible to transition
No
between
question.
different schools, like you were mentioning. So thank you for that suggestion.
I'll just say though, I don't know how that program works now, but I know in the past, not every school would offer the same courses. And so I think that's dependent on the availability of that AP course. I assume that's still the case. My school only offered it for sociology and psychology for whatever reason. So I think it would that would only be helpful if your school offers that college credit AP course. But maybe you know more about that.
One other thing I'd like to mention is that as currently written, this proposal is available for college students to continue that work in service and receive tuition credit. So thinking about maybe that's an option for high school students performing service, but also would that kind of carry over once they're in college and taking college classes, how to incorporate that as a class?
And I think that's going to depend largely on the college. If the college is looking for the student, they'll admit it.
Further questions from the committee? Yes, Representative Woodcock. And Representative Hall.
This is
I
good
didn't see you around
Thank you,
the corner.
Representative Hall. Go right ahead.
You're thinking of how to do it.
Thank you, Mr. Chair, and thank you for taking my question. I would think, well, I'm looking at this 20% number, and I'm going to follow up on Representative Plaid when he said high schools do indeed, for graduation, they need to do community service. So would you believe, which I have to make it a question, so would you believe that, I guess I'm thinking that we need to know, you need to know how many schools make that a requirement for graduation, that they need to do so many hours of community service, because you could have a lot of schools at 100%. It wouldn't be 100% because they don't all go on to school, but it could be a lot more than this 20% number. So just, I would suggest getting that number.
That is a great thing to seek an answer for. Thank you for raising that question.
Thank you.
Representative Woodcock.
Thank you, and I appreciate the opportunity to speak again after Representative Hall. I know it's a quasi-work session as you're here, Morgan, you won't be here at the other time. But as I was listening to the dialogue, I was thinking when Representative Ladd talked about would they get credit for volunteering, that obviously that wouldn't be the same if it was a high school requirement. They really wouldn't be volunteering to do the class. But beyond that, I was thinking reverse. Two parts of your bill is how to get, and the Representative Cordelli brought the big issue of the dollar, which is accurate. It is a big issue on this one, 25 million. If you thought about two things, A, if you made it only for high school youngsters going into college, if that was your intent, if that's smaller the bill, and secondly, if you're going to do the reverse and had just college age youngsters participating, then perhaps it could be something that would be reduced if they worked in New Hampshire after graduation. So that would come off of there. So you're cutting revenue, but you're also working to keep people in New Hampshire. Just thoughts as you're thinking about how on this construct for this bill, how it could possibly pass. Just thoughts. Thank you, Representative Ladd, for the leeway.
Representative Cordelli.
Thank you. Thank you very much for bringing this forward and both being here. I would just point out when you're looking at the 20% of students taking advantage of this and the $25 million per student, that was based on just the high school students. But college students are also eligible for this right now. So the cost could be considerably higher than the $25 million price tag in the fiscal note. So you might want to consider the eligible student population that you're dealing with.
Right. That's a good point.
Any further questions or brainstorming on this bill?
Well, that's interesting.
Thank you very much.
And thank you, Mr. Chair, and to the committee. And it's been an honor to work with Ms. Casey, and I think maybe she's better at this than me. And I'm honored to have brought this forward with her. Thank you.
Thank you.
So, thank you, Mr. Chair, and thank you for the committee letting us present this proposal today. I also just want to say once again, thank you to Representative Schultz and Representative Leno for your guidance and support in this pursuit. So thank you.
One of the things, just to wrap it up, when we moved forward with the dual and concurrent enrollment program, when we went forward with some of those programs which assist high school students to get credits prior to graduating from high school, we slid into the program rather than going full bore. We only had grades 11 and 12. We've since gone down to grades 10, 11, and 12. And we once had only STEM courses. Now we're allowing to be any course. And so once you get it going, get the roots in the ground, then you can expand. And that's how we've done many programs. So it's something you might, look at. Is it better to just go get 80% or 50% now and then expand it in a year or two once it really gets rolling? Something to consider.
Excellent.
Thank you for that feedback.
Yeah. All righty. Well, with that, we don't have any more testimony on that bill, so we'll conclude that hearing. And we'll see everybody tomorrow morning at what time? 9. Is it 9? Who scheduled that?
Electricity pending?
Yeah, no, that I've heard that we will be meeting. Those are the finance bills, but that's fine. You know, we all don't have to be here.